Pardon to mention, my lord. More than 7 years, my lord.
Lordship, there is one matter which is there in the Lordship. It's that court pure matter, or the court manager court pure matter. In fact, your Lordships, we had mentioned, but this week that is not there. The only things are not getting the salary.
It's a today's daily list. We have only got this phrase admission.
I know, your Lordship, but the only urgency is, even though Mr. Mishra
had asked Mr. Mishra to have the.
yes, but they're not releasing or doing anything. If they
No,
come
today's
tomorrow-
list is
Only for
phrase
phrase matters.
admission. So it may come tomorrow though.
Lordship,
If it's there in the list, it was there.
it was there in the
So
weekly list.
Don't
got
think that
deleted.
it is only for. I think it is only for today's list. Yes, it is only for today.
We may
That's
expect it tomorrow.
No,
Lordship.
there is no problem.
more than 9 years ago, question.
Order to mention in Lordship,
May I
challenging the selection list for Odisha Judicial Service, your Lordship. The urgency is it is for 2022.
No, it was there in the list.
Lordship, in the next weekly list was there, but it didn't
No,
reach.
अरे कहलु परा हमें আজি से जो ये रो केवल हमें फ्रेश एडमिशन गुडा का आज आछि तो जो बाकी गुडा को जो फाइनल डिस्पोजल मैटर गुडा काल तो आसीबा तो आज दियो तुम
Of the same weekly list.
don't give it. Only fresh admission matters for today we have brought it. The other matters will come seriously by ବୁଝିଲେ ନି ନା କଣ କାଇଁ ମେମୋଟା ଦଉଛନ୍ତି କହୁଛନ୍ତି ହଁ withdraw
May I pardon to mention, my lord, item 29.
please
Item
wait
29.
please use the mic ma'am.
In today's list, serial number 37, your Lordship, praying for a short adjournment. Can it be taken up next week?
37.
My lords.
What do you want?
Adjourn.
Short adjournment, your Lordship.
Is there any interim order?
No, your
Then
Yeah,
after vacation.
after vacation
37.
देखिए
May I pardon to
tomorrow
mention?
vacation ଅଛି
Hmm.
item
May I
30.
pardon to mention?
What is your good name? You have got power in this case. What is your name?
Yes, okay.
Yes, Rao. That's right. After puja holiday. Yes.
No, regarding compensation rules.
Yes.
May I pardon to
9, my
mention?
lord.
Item 29, my lord. Item 29, my lord.
What do you want at item 29?
Item 9, my lord.
Ah.
Can it be taken up on 7th or 8th? Actually, as a matter of fact, annexure 1 is incomplete. I am filing one amendment petition. Office didn't allow me to file those documents, laptop documents. So I have
After vacation.
prepared one amendment. 7, 8.
After puja holiday.
After
After puja holiday.
Can it be an 8th or
No, either. Next week we do not.
May I pardon to mention item 29, my lord. 29, my lord. Yes, proceed. Kindly take up after vacation, my lord. It is just admission. I mean, all right. Obliged, my lord.
Weekly list, item number 1.
Please, your lordship. The petitioner is
Consulted was right.
Yes, so what is your prayer in this petition?
in this petition, your lordship, passing of annexure 6, your lordship. Petitioner is the wife of deceased, your lordship. The husband of the petitioner working as a messenger in the judgeship of district judge Philbani, your lordship. At the age of 41, he died due to cancer.
For compassionate appointment.
Compensate appointment.
Why it has been rejected?
Rejected due to that less than 44 points has been awarded to the petitioner. For that reason, it has been rejected. Because taking into consideration of section 2B of the notification, your lordship. That notification I have quoted in the rate petition.
Yes.
Also para 10.
So did you assess it in your own way?
I have
Keeping, it should be more. or less?
One,
What is
1 point more may be awarded.
maybe?
Because the petitioner's sons and daughter is studying in class 7th, 8th and 3. For that reason, there is a little bit of probably correction need to be that in that point.
What is the that mark page number?
As your lordship, that
No.
is annexure 8, annexure 7, kindly have a class.
Annexure 7.
Yes, your lordship.
Series.
Annexure page 34 is the
Hmm.
15 years and up to 20 years, 8 marks point have been awarded, and the money, the rupees which has been received by the petitioner, that is
So which according to his on which column,
Which item?
which
Yes.
item you
Part 1, which item?
part 1, your page 36, your lordship. Kindly
Page
wait.
36.
Yes, your lordship.
Page 36. Yes.
That is the class in which studying class 7 and class 3 points awarded 6 and 10.
8. Page 36. No, class 10 is 3 point.
Yes, class
And-
10 is 3 point,
And
class 9 is 4 point, class 8 is 5 point. I am studying at class 8, that is 5 point.
you should get 5 point. So how much it is awarded?
No, right now I am in class 8th.
Right.
In the time of application, I am in class 6th, but inadvertently it has been filed as class 6, class 7. For that reason, it is 6.
So this is for all for the information that you have faced to the authority.
Yes, your
They
lord.
have marked it.
I,
So if you want, you can consolidately, you can again approach.
yes, that may be
Let
for
me
that
put it
reason.
correct.
ଏ ଯୋଉ କେବଳ ଏତିକି ଡାଟା ଭୁଲ ହେଇଛି
With
ଏଇ
regard
data
to the
full
study, class of
ଆଚ୍ଛା ଏଇ
Yes.
ଡାଟାଟା ଭୁଲ ହେଇଥିଲା ଆପଣ କେତେ ପାଇଥାନ୍ତି?
କ୍ଲାସ 5 ରେ ପାଇଥାନ୍ତି ମୁଁ କ୍ଲାସ 6 ରେ 7 ମାର୍କସ ପାଇଥାନ୍ତି ଆଉ କ୍ଲାସ 3 ରେ 10 ମାର୍କସ ପାଇଥାନ୍ତି ହେଲେ
କେତେ
7
ପାଇଛନ୍ତି ଆପଣ?
ଏଥିରେ 16 ଦେଇଛନ୍ତି।
ହଁ 16 ଟା 17 ହେଇଥାନ୍ତା।
Yes.
17
କେବଳ
ଏଇଟା ତ ଗୋଟିଏ ମାର୍କ ବଢିଥାନ୍ତା।
ଗୋଟିଏ ମାର୍କ ବଢିଥିଲେ
କେତେ
40
ଦରକାର ଟୋଟାଲି?
I have awarded 44 marks in total. 1 marks to come into the fold of that notification. 45 heଲେ I am
Madam, kindly clarify that it is at the time of submission.
yes.
This writ petition has been filed by petitioner Sangeeta Nayak with a prayer for a direction to pass the order dated 15/4/2024 passed by the Learned District Judge Kamnamal rejecting her application for appointment under the Rehabilitation Assistance Scheme under the provisions of Orissa Civil Service Rehabilitation Assistance Rule 2020 as per Annexure 6 with a further direction to the opposite party number 2 to consider her case for appointment under the rules. The Learned Counsel for the petitioner submitted that the husband of the petitioner was co-paragraph election. The
Lordship died.
husband of the petitioner was the prosecutor in the office of Civil Judge Senior Division, Assistant Session Judge, Women's Court Fulband, and he died due to cancer on 4/6/2023, leaving behind the petitioner, one daughter and one son. And when she applied for appointment under Rehabilitation Assistance Scheme, the total marks awarded to her was 44, and the qualifying mark was 45. The Learned Counsel for the petitioner submits that so far as the son of the petitioner, it is son or daughter is Sujyo. Son of the petitioner is concerned, who are the first child.
Second.
Election is the first child is heading. ଆପଣ କଣ ନାମଟା ଦେଖୁଛନ୍ତି ତ?
First child.
ଫାଷ୍ଟ ଚାଇଲ୍ଡ ଦେଖିଛନ୍ତି ପୁଅ ବୋଲି।
First child Surya Swadiksha Pradhan, that is daughter, your lordship.
Oh, Surya Elliot.
डॉटर है
Daughter.
Ronit Pradhan is the son.
अच्छा, पहले ये daughter.
Correct. First child with a daughter, namely Surya Sudhiksha Pradhan, was reading in class 6 at the time of application.
Yes.
And as per the column prescribed, he should have been awarded 7 marks. Points should have been awarded a 7, but inadvertently it has been mentioned to be class 7 and class 6. Points awarded is 6. And if the said mark is corrected, if the said point is corrected, then the petitioner would come under the qualifying marks. The land council submits that inadvertently while submitting the application, it has been mentioned that the daughter was reading in class 7. In fact, documentary evidence is available with the petitioner to show that she was reading in class 6. And therefore, the petitioner may be permitted to make a fresh application, which may be considered by the authority in accordance with law. The Land Council for the state has no serious objection to them without expressing any opinion. So and so, if any fresh application for appointment under so and so scheme is made within a period of 4 weeks from today, 4 weeks from today, the authority shall consider a fresh the same and communicate the order to the petitioner within
2 weeks thereafter.
within 4 weeks from
4 weeks thereafter.
4 weeks thereafter.
Then I consideration that I'm pending.
That
4 weeks thereafter.
that order
Correct.
very matter
Best, best, no.
Needless to say that the since the dispute is only relating to the educational the class in which the daughter was studying at the time of
Submission.
first application, the petitioner shall provide necessary documentary evidence in that respect. Disclosed law. Okay.
Item number 2.
May I please? Annex 24 is the order imputing increase to the state fiction matter. Matter relates to appointment on compulsion ground. The Honorable Tribunal was pleased to dismiss the.
Please use the mic properly.
The Honorable Tribunal was pleased to dismiss the original application on the ground. The respondent, opposite party, they have rejected, saying that petition number 2 found unfit, but did not communicate at any point of time what are the disease and what is the percent of disease mile. You should only certificates.
So you are challenging the order dated 5/6/24.
24 annex 24 mile. May April mile.
Yes.
Your lords may kindly give you a glance. Only the page 63, that is internal page 9 of the order of the one tribunal mile. Para number 9 mile.
Paragraph
9.
Okay.
Of the internal order.
Yes.
The medical board report of railway is updated 31st August 2019, and according to the applicant, upon re-examination after more than 4.5 years at AIMS Bhubaneswar on 23rd March 2024, he was found clinical fit in all respect, which may be possible with due medication and, thus, cannot replace the report of medical board of the railway at this stage. So my submission before my lord is that on the last occasion when this matter was placed before my lord, your lordship directed me where I have submitted that for first time by way of annexure R/2. They supplied me the medical documents. Accordingly, your lordship asked me hurry that counter. So I have filed counter and my result along with the additional affidavit. Your lordship kindly give a glance my additional affidavit. Annexure R by 3, page 33, Lordship kindly give. For first time by of annexure, before the learned tribunal, they have communicated me, my lord, these documents. So after receiving these documents, the applicant petition number 2 examine at Ames Provincial of Mila immediately.
Additional affidavit, what you want to do?
My lord,
Additional affidavit,
I have filed the counter and resumed the file before one tribunal, my lord. My submission was first time annexure R by 2 communicated to the applicants, my lord, by of annexure to their counter. So at no point in time there is no occasion on part of the petitioner to receive the same, my lord, to know what are the elements, my lord. So only they have issued some medical certificate saying that you are unfit in C1, my lord. So for first time when they supplied me, so the applicant number 2, he himself examined at Ames sponsor. You also can give a glance. Para 2 of my rejoinder, my lord. Page 39, my lord. 39 and page 41. The applicants, after receiving the counter and going through the grounds for rejection of compulsory appointment, decided to go for a medical checkup of the applicant number 2 at Ames Bhubaneswar. Accordingly, the applicant number 2 on so-and-so registered himself as outpatient and received the outpatient card within the front and thereafter different medical checkup conducted. After detailed test plus checkup, the Ames Bhubaneswar has issued the clinical fit certificate dated so-and-so. Now, my page 41. Second subpara. It is respondent stated that from page 33 of the counter, it appeared that the respondent number has accepted the finding of medical board. The report includes as annexure R by 2 series, though of this applicant was never communicated to him and for first time enclosed to the counter, my lord. So my submission was only for re-examination, my lord. Only to conduct my medical retest or re-examination for assessment of my disability, whether I am fit or unfit, my lord.
No, you come to page 74 of the counter affidavit, which
Page-
is internal page is 5, running page is 74.
74, my lord.
74. Additional affidavit filed by the petitioner जोटा अछि
ଆଜ୍ଞା
तादर आपण annexure 25 टा होची counter affidavit रो copy ଦେଇଛନ୍ତି तार internal page 5 question counter affidavit जोटा file करछंती respondents तरफु ताको आपण additional affidavit रे गुंथि ना दी
ଆଜ୍ଞା
तार page 5 को आसो
ଆଜ୍ଞା
पाइले
page 7. Internal page 5 of the counter, man.
yes Please read it. That
The candidate has been examined by ACHDP MCS. The case of applicant has been dealt by CHMCS. He has been advised for hospital admission for the evaluation of 3-member medical board, and the applicant had also written in the candidate's declaration registered but not turned up till so-and-so. A letter accompanied by the unfit medical certificate dated so-and-so has been issued to respondent 3 on 24th March 2017, wherein it is informed that after conducting medical examination of the applicant 2 on 17 March 2017, the treating doctor found the applicant, that is, applicant number 2, as unfit due to hypertension and advised him to take admission in Central Hospital, Manchester on 18th March 2017 for high blood pressure, but the candidate has been absconding since then. The matter has been communicated to respondent 3, and who in turn intimated the applicant number 2 by letter dated 6th April 2017. In view of such type of scenario, it is also advised in para 5 of the said policy letter of railway board how to deal. Extra of para 5 is appended. Thereafter, they sent me for medical examination.
you see their what is their rules.
In case the candidate abscons or himself or absent himself willfully prior to / during examination by the 3-member medical board, this fact should be recorded, and the decision of the first medical examination would prevail, and no further appeal shall lie with any higher authority, including railway board.
So 18/3/2017, that is the date of your first examination. Then it was found to be physically unfit. Right. Then another date was fixed, but you did not attend that. That is the rule, that the first, in that case, the first medical examiner's report would prevail. So accordingly, you are declared unfit. What certificate you produced, that was of a much later period.
So, after this, I made an appeal. There is an appeal provision. They referred me to Waltier. At Waltier Hospital, private, they conducted my checkup privately. On basis of the report of Waltier Railway Hospital, they declared me unfit. Later on, in the year 2019. So my submission before with that, they have only issued the medical unfit certificate without assigning any reason. When assigned the said order, medical certificate.
No, the medical fit certificate comes on 23/3/24. So you see the time gap between that period and in that second one, you found to be clinically fit. So the question is whether when the test was conducted, first test, since you are not physically found to be fit, you are disqualified.
May I payment? Your Lordship, kindly give a glance, page 35, Annex 14.
Yes.
Along with this letter, my lord, page 33 communicated to me. The medical certificate declaring me unfit on 20th September 2019.
Yes.
Only this one.
No, your claim is that when you got yourself tested outside the railway hospital.
I have questioned the medical test conducted at Waltier, my lord. I questioned the medical test conducted at Waltier. My solution was
that is found to be fit.
No, my lord.
Then that is not found to be. So consistently, the railway doctors who ever examined, whether 3 doctors or in Waltier in journal or single, all have been found to be unfit. So individually, when you got yourself examined before in a third hospital, that is AIMS.
Of course, in 24.
In 24.
You will pending of the way, man.
And after a medication.
Because, my lord, I was not aware what is my report, my lord.
No, they said that it is hypertension. They have made it very clear.
In the second medical examination.
Whatever. After second also, you did not comply that.
They have assigned so many reasons.
No, they asked you to get yourself admitted because they found you to be high blood pressure, hypertension. You did not obey that. You abandoned it. You absconded. And thereafter, again, you reached the office and you were examined in Waltier.
if you come to annexure 15 also,
Hmm.
page 36, just come to that.
My lord.
एटी मेडिकल री-एग्जामिनेशन फॉर कंपैशनेट अपॉइंटमेंट
Yes.
हला
Again.
पढନ୍ତୁ सेटा
Your appeal dated 30th October 2020 has been examined on basis of your initial application for compassionate appointment. You were medically examined and declared unfit by a medical board. The same was communicated by this office, letter number 6/17. Further, in the light of Cat Kotak's order in also medical re-examination was also conducted by medical board at a DRS, Divisional Review Hospital, Valtier,
Hmm.
on 28/8/2019 and found unfit in C1. The same has been communicated to you by this office letter number 14/10/19. The Lordship kindly give a glance, page 36, the like 14/10/19 letter, man. This is not a report, man. Page 35, man.
whatever it may be, twice you have been medically examined and you are found to be medically unfit. Now their scheme of thing is that if the first report would count in case you got the further treatment, then it is all right. If you abscond, then the first report would count. And here is
In
the
this
case.
case, I am not absconded, my lord.
आपण डेट फिक्स up आपण ଆସିଲେନି से ही we are not going to enter into their disputed.
Now, my lord, my submission, they have relied upon Annex 20, my lord. Your lordship to has to examine whether the same is applicable to my case or not.
Yeah.
Page 43, my lord.
Some decisions were cited, given to you. Have you examined those decisions?
No, these are not applicable to my case, my lord. Because my claim is based on specific scheme and there is no prohibition or there is no standard fixed in the compassionate appointment scheme to provide employment on compassionate ground, man. Scheme will be silent to that.
So compassionate appointment, one of the schemes that you are to be found physically, medically fit.
Treatment.
So if that is not there, can you get it?
So my lord,
when that was examined 2017, then 2019, every time you are found to be physically unfit. So now suppose in 2024, you obtain a certificate of outside, that is.
I am only praying, my lord, I may be examined at CH Montessori, man.
No, you cannot choose the authority. There are there may be some specific hospital for that where the test is to be conducted. Otherwise, if the liberty is granted to the persons, then they may get it from other hospitals that they are free.
No, Central Hospital Railway.
So,
Central Hospital Railway, man. As because at Valtier I face much difficulty, man. And moreover, all tests conducted privately, man.
now who are these two persons?
Hello?
Who are these two persons? 54 is the widow and the son.
Son, man.
So for whom you are
Son.
Son. So this in the scheme of thing it is there. That,
My lord.
What is that? Let us see that scheme.
May I put my lord? You will also kindly come to page 18.
That is the scheme.
The letter issued for my appointment, my lord.
No, that's all right. We have to see the scheme. When the widow is there, son is there, daughter is there, then how they will get it? So, what is that scheme?
Answer 18.
Hold on to quote a relevant.
Page 39. In case candidate have the necessary minimum qualification for employment in Group C, son, daughter, widow of the employee are eligible for appointment on compassion ground.
Okay.
In case candidate has the necessary minimum qualifications for employment in Group C post, his suitability for all types of Group C post in order of suitability should be judged and recorded by the screening committee, which should also clearly indicate the categories for which the candidate has not been considered suitable. Final offer of appointment will, however, be subject to availability of vacancy, passing of medical examination, production of necessary certificates.
Yes.
Normally, only the father is taken to be breadwinner of the family, where both husband and wife are railway employees. Consequent upon the death of husband, appointment on compulsory ground is admissible to a ward, but not on account of death of wife. In such cases, only one compulsory appointment is admissible. This has been modified to the extent that compulsory appointment is admissible in case of death of mother or father, subject to stipulation that compulsory appointment will be available either on death of the husband or wife, whichever, on account of first. Railway employee dying in harness, leaving more than one widow along with his children born to second wife, the appointment on compulsory ground to second widow and her children are not to be considered unless administration has permitted the second marriage, taking into account the personal law. Second marriage is not permissible is invariably specified in terms and conditions are advised in the offer of initial appointment. Where the widow cannot take up employment, the railway can keep the case for appointment on compulsory ground open to enable consideration of appointment of a minor son when he attends majority. Even though at the time of occurrence of the event, making compulsory appointment permissible. There is
a daughter
who has attained majority and or a major son who is already employed. This will be subject to following conditions. The minor son to be appointed will be attaining a majority of age with a period of 5 years of the death, event of death, which is the basis for appointment on compulsory ground. Where there is more than one minor son, it is the only eldest minor son who should be considered for appointment when he attains majority and not any of the other minor sons. Further, in such cases, the competent authority should be satisfied about the bona fide of the request of the widow, or if there is no surviving widow of the family, that appointment should be given to a minor son when he attains majority instead of a daughter or an employer son who is already major. For recruitment in Group D, the following posts for appointment on compulsory ground are exclusively reserved for widow, and in respect of these posts, minimum qualification.
Come to the next page, sir. Page 40.
Normally, the appointment on compulsory ground should be made within 1 month for item 1 and within 3 months from others. But all of the fools should be made to offer appointments as well as possible. A period of 5 years from the date of occurrence of an event is prescribed as period of eligibility of entitlement of appointment on compulsory ground, which may be relaxed up to 20 years with the approval of general manager. In all cases of death or of an employee while in service, and in cases where the widow cannot take up employment, sons or daughters are minor, the case may be kept pending till the first sons or daughters become major. Compulsory appointment, as permissible under the extent instruction, would be provided by the general manager even beyond the limit of 5 years and up to 10 years, subject to the following conditions.
So in this case, who actually filed an application for?
Widow filed an application for her son.
Where is that application?
That application not I have enclosed, but they consider the same and issued annexure 2 minor. It will also kindly give annexure 3 minor. Page 18.
Yes.
Page minor, they conducted the screening test. This applicant found suitable minor. Annexure 2, page 17 is of letter dated 21st February 2017. Thereafter, annexure 3 they have issued minor. Sir Abhijit Mahanti, son of late Saroj Kumar Mahanti, has been found suitable for fresh appointment of Group D post on compulsory ground. As such, Sir Mahanti is directed to report you for necessary medical evidence. So he was considered and he was found eligible subject to medical fitness. It is not that there was no vacancy or was not considered. There is any dispute over my candidacy concern. Only question is that they declared me for first time is having hypertension minor only. But subsequently, in the Waltier Hospital minor, they assigned so many reasons without communicating the reports to me. They have issued only me the medical certificate. So I made an appeal, they rejected. Then I approached the Lord Tribunal. May I pray, my lord? If Lakshmi kindly give only one Observation of Lawrence Tribunal.
You see, you say that there was no communication from the after your first examination, right? That was your
Second examination.
19 after 19.
19 exams.
19 exams.
କାରଣ 2017 ଆପଣ ଫାଷ୍ଟ ଏକ୍ସାମିନେସନ ପରେ ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଛନ୍ତି
ଆଜ୍ଞା ମୁଁ ଅପିଲ ଦେଇଛି ମୁଁ ଅପିଲ କନସିଡର କରିଛନ୍ତି ମତେ ଓଡିଶା ନ କରିକି ବା ସେଣ୍ଟ୍ରାଲ ହସ୍ପିଟାଲ ଭୁବନେଶ୍ୱର କନସିଡର ନ କରିକି ସେମାନେ ପଠେଇଲେ ଡେଲିଭରେଟଲି ଟୁ ୱାଲଟିୟର ମାଇଲ where there is no kind of facility available.
So this 47 page 47 has not been communicated to you. 48.
No, mala.
Page 2.
Page 2
is 349.
Mala.
Here they have given the recommendation of the medical board.
Mala, these documents communicated to me as annex R by 2
in
the counter before the law tribunal.
Annexure?
Yeah, annexure.
Page 21, ma'am. Page, sorry.
Page 46.
Page 46, 47, 47, 48 and 49.
That is the medical board.
These three documents communicated to me as annexure R by 2 to the counter before law tribunal. And after receiving the same, I examined. As because I questioned the medical test conducted at a Waltier.
हम लोग पेज 49 को ଆସିଲେ
Maila.
Your recommendation ଅଛି ସେଟା ପଢ.
So Abhijit Manti was examined by standing medical board on 28/8/2019 and was found to have hypertension. The committee decided to hospitalize him for observation and continuous recording of blood pressure. He was admitted in Divisional Relief Hospital Waltier from 28/2019 to dated 31st August 2019, and his BP was recorded 6 hourly without any medication. During this period, his BP varied from so-and-so to so-and-so. He was investigated for end organ damage. Incidentally, he was detected to have high fasting and post-prandial blood sugar levels, and also grade 1 renal parenchymal changes on ultrasonogram, concentric LBS on echocardiogram. The members of the medical board reassessed his condition on dated 31st August 2019 in view of the above finding and also separately recorded his BP and his RBS was also with sugar phases in his urine. Hence, it is evident that the candidate is suffering from hypertension, diabetes mellitus with end organ damage such as grade 1 renal parenchymal changes and concerning left ventricular
So this is the second report.
Yes.
First report is annexure.
First report is only medical hypertension.
That is annexure. Annexure 2.
Page 19, my lord. Annexure 4. Medical certificate, page 19, annexure 4.
So where have you taken the ground that it was not communicated to you in that original application? Have you filed that original application?
My lord, I have that pleaded after receiving this document. I have pleaded in my region. For first time, they are communicated annexure.
Kind of equal line. Region report.
Let me kindly come to the internal page 3 of my region or my
internal page 3. Okay. Yes.
Second subpara. It is respectively stated that from page 33 of the counter, it appears that respondent number 5 has accepted the finding of medical board. The reports enclosed as annexure R by 2 series, though of this applicant, but never communicated to him, and for first time enclosed to this counter.
Yes, what do you say, Mr. You are appearing.
I'm appearing on behalf of Learned DSJ, man.
Yeah.
On this part, man, I have to take instruction, man.
This writ petition has been filed by the petitioner Vijupta Mahanti and Abhijit Mahanti, challenging the order dated 5/6/2024 passed by the London Central Administrative Tribunal Kotak Bench Cutter in OA number 260/00303 of 2023. Maidan issue 24. Plan counsel for the petitioner submitted that the husband of the petitioner number 1 and father of petitioner number 2 was working as senior stock verifier at Divisional Railway Office Jatni, and he expired on 17/7/2016. After death of the employee, petitioner number 1 submitted application nominating petitioner number 2 for employment on compassionate ground as she was ill and ailing. The Land Council further submits that the opposite party number 2 advised the petitioner number 2 for screening test, public document verification, and after the document were verified, it was found that he was suitable for fresh appointment in a Group D post, and accordingly the opposite party number 3 directed the petitioner number 2 to report for necessary medical examination. The first aid medical examination was held on February 17 17/3/2017 at 24/3/2017, and he was found to be medically unfit as he was suffering from hypertension. Land Council submits that for the second time the medical examination of the petitioner number 2 was conducted. That is annexure kede second jota annexure 21 na kede
21.
In the year 2019 at Waltier na
At DRH Waltier.
at DRS
Divisional Railway Hospital.
at a Divisional Railway Hospital, Waltier, and there also it was found to be medically unfit. However, the order was not communicated to the petitioner, and the petitioner would come to know about the same in
encounters.
paragraph election देखुथिले
Page 3 of my rejoinder mail.
Would come to know when those documents were annexed to the counter affidavit filed by the opposite parties. The Land Council submits the what is that AIMS report?
Let's take go for it.
That is annexure 21 series to my rejoinder.
21 series.
Mail.
Page 49. 21 series now. But I am
and annexure 23 series to my read petition, and also annexure 21 series to my rejoinder before on time I have filed that along with the additional affidavit.
Page 51 alla.
51 to 54.
Petitioner was examined in March 2024 in All India Institute of Medical Science, Bhubaneswar, Odisha, where it was found to be physically fit. Second टा जो लिखी हुई है तारा region टा ठीक लिखी देंगे that on the ground of he was detected to be have high fasting and postprandial blood sugar levels and also grade 1 renal parenchymal changes on ultrasonogram. So and so it
page 3
page 3 page 49 होची running page, page 3 होची
internal
picture 21 right internal है ना. The land council submits that in view of the state of affairs, the Central Administrative Tribunal should not have rejected the original application filed by the petitioner. এটা দুইজন ফাইল করছিল না কি এটা
Mother and son,
by the petitioners.
by the petition.
Holding that there was no infirmity, illegality, or irregularity in the decision-making process of the matter so as to indulge and interfere in the matter. Issue notice on the question of admission indicating therein the matter shall be disposed of at the stage of so and so. Learn Mr. Party.
Mr. Kashyap is appearing in this case.
Kashyap.
SS Kashyap.
SS Kashyap. You will appear for whom?
He was appearing earlier.
Yes.
I know only the appearance of learned DHA may be restricted, man. Our panel is no more.
Extra copy we saw the matter will be listed after so and so. Counter if any file listed. So the observation of the I've got a line the observation of the learned tribunal that the applicant has not produced any solitary evidence to disbelieve the report of the railway medical board so as it was the order so and so is not correct in as much as the report of the All India Institute of Medical Science is very clear in that respect.
Item number 3.
May I please, Your Lordship? Lord,
It's not possible.
this is the case of a person, a distressed person.
That in Annexure 11 of reconsideration. Annexure 11. Page 50.
May I please, Your Lordship?
Annexure 11 is pending before whom?
Lord, I have came before this honorable court earlier in another case that is I'm coming on.
Lord, you made representation under Annexure 8 because
And they say that
already paid.
they said that it is paid. But I in RT I have asked them that please give me the detail.
That is Annexure 10. Annexure 10.
Yes.
Then you made application in Annexure 11.
11 is pending. That is since last 1 year it is pending.
Annexure 11 is pending with whom?
It is pending with the collector.
Opposite party number?
Okay, no. I'm coming in. OP number.
Collector Sundargarh.
Yes, Lord.
OP number.
OP number 2 collector Sundargarh. That is to be disposed of. All right, next.
That way disputed only or
Within 3 months.
Within 3 months and it is to be communicated within 15 days of the taking the decision. Yes.
Item number 4.
Yes, Lord. I received the counter. You are directed to take instruction on the. Yes, sir. Today, my Lord. I'll It may come some days after I will take instruction.
Uh,
Sort of a report in that case that they have filed unconditional apology manifest. Inadvertently they filed.
the superintendent DB2 has submitted the explanation as per order pages one. So here is the explanation. We find it to be satisfactory. Yes, what do you say in this matter?
This is a case, your lordship said he has claimed for the aerial
Yes,
survey of his father, my lord, from 1999 to
2002.
my and your lordship has directed me to take instruction whether
It was paid or not. It
Paid
wasn't
or
paid on.
he has already, my lord,
Deed and documentary proof has also
I
been.
will file today, my lord, because
So what do you want?
I'll take instruction on today. I will see.
I have also solved the copy.
Yes, yes.
The learned counsel for the petitioner submits that he has received the copy of the document from the learned counsel for the opposite party relating to disbursement of arrear salary of the of his late father of the petitioner for the period from 6/10/2001 to
99 to 2002. 99 to 2002.
No, my claim was 99, but he said that
my lord, because he was at that time he was not treated before the medical board, my lord. That period was treated as
So now you said that the claim has been paid for this period.
It is
2001 to
and previous my lord, he was not entitled to get.
6/10/2001 to 36/2002, and he wants to take instruction on this document, and the matter may be taken up after ensuing puja on this matter. Yes.
But he has stated that from the entire period I am not disputing.
No, it's all right. See you period of
Yes.
Pauchandi, Paichandi, Deichandi, let him take that also.
Oh, bless you.
Item 5.
Please, your lordship, my lord, I have filed a IA for amendment. That is not listed.
IA for amendment.
Where is that amendment, Pitson?
My lord, sorry, my lord, amendment petition filed on 27/9/2024, my lord.
That is not
Friday.
before. What amendment you want now?
My lord, previously I filed this writ application with a direction to the Tahsildar to dispose of the lease case under the OPL Act, but he disposed of my lease case under the OGLS Act. So the Honorable Single Judge remanded the matter before your lordships, and so I filed an amendment petition for quashing the impugned order, my lord. That I have not mentioned in my prayer. My lord, the impugned order is Annexure 9.
Annexure 9.
My lord. Annexure 9, my lord. My lease.
9 copy of the order of the Tahsildar
My lord, that is the impugned order. If your lordships permitted me, can I place my lord?
Just a minute. Annexure 9 to go to content fiction about you.
Under the finding of the
wait.
52, my lord. Page 52.
Egara 3/24.
My lord.
Passed by Tahsildar.
My lord.
Tahsildar Khurda. So according to you, he has disposed it of on the basis of OGLS.
OGLS.
It should have been under the
OPL, my lord.
ସବୁ paragraph ରେ ଆପଣଙ୍କର ଇଏ କରିବ
No, my lord, prayer,
paragraph ରେ
my lord, prayer,
entire
no, only,
body you have to go.
1 ରେ paragraph 2 paragraph 3 ସବୁଥିରେ ଆପଣଙ୍କର
my lord, same thing, my lord. Prayer जोटा सेटा same as to cost item, same as to paragraph 1 and the paragraph 9 also, my lord. Same, my lord.
Mr. Misro,
My lord, copy of the amendment may kindly serve them. Copy of this
My lord.
I may object to it, my lord, because
Kono?
even the nature of the
Nature of case.
and the orders passed by this honorable getting serve a copy.
So I have not extra copy. If your lordship direct.
IN number 13169 of 2024. This is an application for amendment. Land Council for the state submits that the copy of the amendment petition has not been served on him. Let the Land Council for the petitioner serve copy of the amendment petition on the Land Council for the state. Put up this matter after entering Puja holidays. The state is at liberty to file objection to the interim application for amendment.
Obliged.
My lord.
In the meantime.
Item 6.
Lord, here I have challenged evaluation of my unsubscription OGS exemption 2022.
Law of purpose. Answer for
Well, may take your lordship to page 57.
57.
57.
I pay.
57.
Yes.
57. Annex of question answer 5A. That has not been evaluated. 5A. 5A to the country. Yeah, today evaluation correct. Total say and 5A.
Just a moment. Question का इंतजार.
Question.
Annexure 4.
Annexure 4.
Annexure 4 होची question.
Annexure 4.
कौन सा question दा थिला देखिएला?
हाँ, पेज होगा. Page 24. Section B.
Yes. 34.
Type A. Type A. Annexure 6, you see, it is there. Annexure 6.
Annexure 6.
Mark is awarded for
5A. Page 57 te
no. Ultimately, it is annexure जोटा की calculation है mark. ସେଇଥିରେ question number 5 रे 4 ଦିଆ ହେଇଛି.
Annexure. ଆଜ୍ଞା A B ଅଛି. A ଅଛି B ଅଛି.
ନାଇଁ total 6ଟା
ସେଥିରୁ 4ଟି ଆମେ ଆନ୍ସର ଦେବୁ.
ହଁ ନାଇଁ
4ଟି ଆନ୍ସର ଦେବୁ.
ନାଇଁ 6ଟା ଟୋଟାଲ ଦେବେ 3ଟା ଗ୍ରୁପରେ 3ଟା ଗ୍ରୁପରେ 6ଟାରେ ଆପଣ ମାର୍କ ଦିଆ ହେଇଛି କି ନାଇଁ ଦେଖନ୍ତୁ ଏଇଠି annexure 6 ରେ question number 2 ରେ ଦିଆ ହେଇଛି 3 ରେ ଦିଆ ହେଇଛି 5 ରେ ଦିଆ ହେଇଛି 8 ରେ ଦିଆ ହେଇଛି 9 ରେ ଦିଆ ହେଇଛି ଆଉ next year ରେ 11 ରେ ଦିଆ ହେଇଛି total 53 ଦିଆ ହେଇଛି 1 2 3 4 5 6
ଯୋଉଟାରେ ମୁଁ
only 6 questions have been marked
କିନ୍ତୁ କୋଉଠି ମାର୍କ ହେଲ୍ପ 57 ରେ ହେଇଛି
why don't you come to annexure 6
57 पे
5 question number 5 रे 4 ପାଇଛନ୍ତି ପରା
କୋड 5 ଯୋଉଟା 4 କହୁଛନ୍ତି ଏଟାକୁ 5 ଏଥିରେ ଦେଲେ ଆପଣ 6 ଟା ସେ
ନା 6 ରେ ଆପଣ କରି ନାହାନ୍ତି ଆପଣ 6 କରି ନାହାନ୍ତି you have not appeared 6
ଆଜ୍ଞା 5B ଏଟା 5B ରେ ଦେଇଛନ୍ତି
সেটা বি তার উপর দিয়ে দেখো তো ভিজিবল হবে বলছে দেখো 5B
total mark तो
পজিশন অফ আপনি বিটা দেখুন
क्वेश्चन नंबर ଆସିଲା ଆଗେ ପ୍ରଥମେ क्वेश्चन ଟା ଟିକେ ଆସିଲେ क्वेश्चन କାହିଁ ଆପଣ
কোশ্চেনটা ହେଲା ଆନେକ୍ସର 5
ନା
5 ଆପଣ
ପ୍ରପର୍ଟି ର ତ क्वेश्चन ଟା
ହଁ
ହଁ ସେକ୍ସନ ବି
ବି
ସେକ୍ସନ ହେଲା 5ଟା ଦିଟା ଅଛି ଏ ଆଉ ବି
ଏ ଆଉ ବି
ଟୋଟାଲ ମାର୍କ କେତେ
25
answer any 6 questions selecting 2 questions from each section
each section
अच्छा ତେଣୁ ଫୁଲ ମାର୍କସ ହଉଛି 150
12 half mark ଆପଣ ଦେଖିଲେ
question from each section ତାହେଲେ section ଏଇଟା ଆସିଲା section ଆପଣ section B ର
A 5A
section B ର ଆପଣ କୋଉ question answer ଦେଲେ
B ର ଦେଇଛି B ଟା ଦେଇଛି
ନାଇଁ ଆପଣ
4 ମାର୍କ ଯୋଉଟା କହିଲେ ବେଳା
each section ରୁ ଆପଣ ଦିଟା question ର answer ଦେଇ ପାରିବେ ଉପରକୁ ଦେଖନ୍ତୁ ପ୍ରଥମେ page 5 ର top କୁ ଦେଖନ୍ତୁ the questions are of equal value right
yes
full marks ହଉଛି 150
right
answer 6 questions selecting 2 from each section ତା ମାନେ ପ୍ରତ୍ୟେକ section ର ଯଦି ଆମେ 150 କୁ divided by 6 କରିଦବା ତାହେଲେ ପ୍ରତ୍ୟେକ ଇଏ ପାଇଁ ରହିଲା
25 ହେଲା
25 ମାର୍କ ରହିଲା
ଇଣ୍ଡିଭିଜୁଆଲ
25 ମାର୍କ ମାନେ ଗୋଟେ କ୍ୱେଶ୍ଚିନ ର ଠିକ ଆନ୍ସର ଦେଲେ ପ୍ରତ୍ୟେକ ସେକ୍ସନ ଆପଣ ପାଇବେ 12.5 ଠିକ ତ ବର୍ତ୍ତମାନ ସେକ୍ସନ B ର
A ମୁଁ ଚୁଜ କଲି
ଆପଣ
A and B
ଠିକ
A and B ଚୁଜ
ସେ
କଲି
B ର ଆପଣ ଯୋଉ ଚୁଜ କଲେ 5 ନମ୍ବର ଟା ଦେଲେ ଆଉ କୋଉଟା ଦେଲେ ନା ଦେଇନାହାନ୍ତି
A ଦେଲି B ଦେଲି
ଗୋଟିଏ ହେଲା
ନା
A and B ଦିଟା ଦେଲି
ଗୋଟିଏ ନମ୍ବର
ମାନେ ଗୋଟିଏ କ୍ୱେଶ୍ଚନ ର ଏ ବି ଦେଲେ
ଗୋଟିଏ କ୍ୱେଶ୍ଚିନ ର ଦିଟା ପାର୍ଟ ଅଛି ଗୋଟେ A ପାର୍ଟ ଅଛି ଗୋଟେ B ପାର୍ଟ ଅଛି A ଟାକୁ ଦେଲି B ଟାକୁ ମଧ୍ୟ ଦେଲି
କିନ୍ତୁ
B is answered B is evaluated as 4 whereas A is ignored A is not looked at that is not evaluated
ଆପଣଙ୍କର ସେଇ ଯୋଉ ଇଏ ଅନୁଯାୟୀ ଟୋଟାଲ ମାର୍କ 5 ନମ୍ବର କ୍ୱେଶ୍ଚିନ ଯଦି ପୁରା ଠିକ ଦେଇଥାନ୍ତେ ତାହେଲେ ଆପଣ କେତେ ନମ୍ବର ପାଇଥାନ୍ତେ
25
କେମିତି
A and B
no
12 half
ଆପଣ 4 ପାଇଲେ ଦିଟା ମିଶିକିରି ଆଉ
ଆଚ୍ଛା ଆପଣ କହୁଛନ୍ତି
ଦିଟାକ ମିଶିକି ବୋଲି ସେଟା କଣ ସବଜେକ୍ଟିଭ ଲେଭେଲ ବୁଝିବା ନାଇଁ ସେଥିରେ ଦିଆହେଇଛି ବୁଝିବା
ମହାନ୍ତି ପ୍ଲିଜ କମ୍ ଟୁ ଦ୍ୟାଟ୍ ଏଗେନ୍ ଆପଣ ଯୋଉ କହୁଛନ୍ତି 5 ନମ୍ବର ଆନ୍ସର ଟା ଦେଖେଇଲେ କୁଆଡେ ଗଲା
57
କୋଉ ପେଜ ଟା ଦେଖୁ
57
ଦେଖିବା
ଆପଣ ଦେଖନ୍ତୁ ଜଷ୍ଟ 57 ର ଟପ୍ ରେ ଦେଖନ୍ତୁ ସେଟା ଯୋଉ ଦିଟା କ୍ୱେଶ୍ଚିନ୍ ଦିଆଗଲା ୟାର ଉତ୍ତର ଯୋଉ ହେଇଛି 5 ଗୋଟେ ମାର୍କ ଦିଆଗଲା +4 ଇଜିକାଲ ଟୁ 9 ଦିଆଗଲା ଏଥିରେ ହେଲା ମୁଁ 5ଟା କଲି 5 ର A କଲି ଆଉ B କଲି ଲାଷ୍ଟ ଦେଲା
ୟାର ଟୋଟାଲ ମାର୍କ ହଉଛି 12.5 ଠିକ
12.5
ତାପରେ
ଏଥିରେ ହେଲା ମତେ 5 ର A ଆଉ B କଲି ତା ଉପରଟା ଦେଖନ୍ତୁ ସେ 57 ଜଷ୍ଟ ପ୍ରଥମ ତା ଉପର ଭ୍ୟାଲୁଏସନ ହେଲା ଯୋଉଟା ମୁଁ କଲି ସେଥିରେ ଦିଟା କ୍ୱେଶ୍ଚିନ ଦେଇଥିଲେ ଆନ୍ସର ସେ ଗୋଟେ କ୍ୱେଶ୍ଚିନ ର ଦିଟା ଭାଗ ଅଛି 5 ଆଉ 4 ଦିଟାକୁ ଦିଆହେଲା ଇଜିକାଲ ଟୁ 9
ଠିକ ଅଛି
ତାପରେ 5 ଆସିଲା 5 ରେ A ଠୁ ଦେଖନ୍ତୁ A ଟା ଚାଲିଲା ତାପରେ B ହଉଛି ଏଠି ହେଲା B ରେ ହେଲା 0.4 ଦିଆଗଲା
ଦିଟା କାଇଁ ଦୁଇଟା କୋଡିଲେ
ତା ତଳେ
ପଜିଶନ ତାପର ପେଜ
ହଁ
58 ଅଛି
58 1 2 3 ଥାର୍ଡ ପାରା ବିଟା କାଲିଛି ଲେଫ୍ଟ ଟିକେ ଭିଜିବଲ ଦେଖେ ପଜିଶନ ଅଫ ମୁଭେବଲ ପ୍ରପର୍ଟି
4 ଦିଆଯାଇଛି
4
It is subjective that we cannot. 4 बार देखते तो 3 होगा 5 होगा 7 होगा how can we say that?
नहीं ये जो तीनटा माने ए और
डिवाइड करके दे
ऊपर देखिए से 5 4 9 पर ସେଇଟା ହେଇଯିବ
ତା ଉପରଟା
ତା ଉପରଟା
ନାଇଁ ସିଙ୍ଗଲ ଦିଆଯାଇଛି 5 ସିଙ୍ଗଲ ଦିଆଯାଇଛି 5
ନା ଅନ୍ୟ ସବୁଥିରେ ଦିଆଯାଇଛି
5
ଏଇଟା ପ୍ଲସ ଏଇଟା ପାର୍ଟ ପାର୍ଟ କରି ଦେଇଛି
4 के 8 ये
ସବୁ ଇଣ୍ଡିଭିଜୁଆଲ ଦଉଛନ୍ତି
4 4 8 ये
ଦେ ଆର୍ ମେଣ୍ଟେନିଂ ସିକ୍ୱେନ୍ସ
प्रथम को देखियो हम आंसर शीट रो 4 4 8 प्रथम रो आसियो
52 ରୁ 53 ଦିଆଯାଇଛି 448
4 ପ୍ଲସ 4 8 ସବୁଠି ଦିଆଯାଇଛି ପ୍ଲସ ଟା ମିଶେଇଛନ୍ତି ଏଠି ତ ନାହିଁ ସେଇଟା ନା
2 रो आपनकर मार्क को देइछि देखियो आइटम क्वेश्चन नंबर 2
क्वेश्चन नंबर 2 क्वेश्चन नंबर हाँ 2 होची पेज 30 ना पेज 30 31 32 33 এটা কো দিয়েছে 33 রে 05 5 মার্ক তারপরে 34 বি স্টার্ট হলা বি টাকু দিয়া গলা এটি 4 মার্কস
44 मार्क है
তো 35
हां
पेज 35
एटा है गला आपनकर
क्वेश्चन जो 2 टा खेल 2 टा खेल सेक्शन ए
हां सेक्शन है
हां
तापर आपनकर नेक्स्ट
ହେଲା 38 ଦେଖନ୍ତୁ 38 ରେ ଲାଷ୍ଟ ଦେଖନ୍ତୁ ସେଥିରେ ତିନିଟା ଥିଲା 5 ପ୍ଲସ 4
5 plus 4 4 5 14 नंबर
14 ହେଲା
एटा काई टॉप रे काई कोड लिखना तो 5 एटा कोड लिख
5 ଅଛି ତା ଉପରୁ ଦେଖନ୍ତୁ 5 ଅଛି
एई जो टॉप
ହଁ ଦେଇଛନ୍ତି
पेज रे
ହଁ ଦେଇଛନ୍ତି ତାପରେ 4 ଦେଇଛନ୍ତି 4 5 ଦେଇଛନ୍ତି
ओइटा 14 एमसीए मन
ଏଭ୍ରି ସେଠି ସବୁଠି ଦେଖେଇଛନ୍ତି
14 रे एठी लिखिया तो सेटा ता तळु लिख दी छै अच्छा हां 4 ओइटा भी 11 मार्क एमसीए 53 क्वालिफाइंग मार्क केते अछि
70 150 or 50% थे बरोबर 150 रो 50%
75 तो आपण पाइतले केते देइला
ମୁଁ ପାଇଥାନ୍ତି ଆଉ 5 ମାର୍କ ପାଇଁ
फुल मार्क आपन दिया
नहीं मैं आई एम शॉर्टेज ऑफ 5 मार्क शॉर्टेज ऑफ 5 मार्क
50% हेले क्वालिफाई करिवे
ମୁଁ ଏଥିରେ ରଖି ଯା ମୋର
आपन को 53 मार्क आपण सेई जो क्वेश्चन टा पई आंसर हेना दि आपण पूरा संपूर्ण मार्क दियाला 6 दे 6 देले आपनकर कहूची 60 मार्क
6 ले हे जो से जा कहय कथा पिला से जा 5 मार्क से जा कैलकुलेशन
अरे आपण कहउजनी 50%
50% सेथरे आई एम नॉट कन्वर्सेशन विथ दिस बट
जदी माने किछि हम जदी यू आर राइट जदी हम माने सेटारे मार्क अवार्ड हे गले हम फुल मार्क भी अवार्ड हे गले आपण जदी क्वालिफाई करि परते मैटर इज डिफरेंट यू आर राइट 100%
क्वालिफाई 100%
देखो सेटा सेई गुडा काम देखान 60 आपण क्वालिफाइंग मार्क केते रिटन नो
क्वालिफाइंग ता देखि क्वालिफाइंग ता केते 50% ना 45% ना
देखो देखो
देखिए
रूल ना देखि दियो एडवर्टाइजमेंट तो देखि
क्योंकि आई एम
हम एटा पास ओवर करछु देख
हां ठीक पास
हां क्वालिफाइंग एटा खाली देखि दो
हम
यस नेक्स्ट
item 7
My lord, item 7, my lord, on behalf of land DSM, I humbly pray for adjournment. Argue the matter.
Adjournment is sought for after puja holiday. Yes.
item 8
My lord, I may pardon. In item 7, I have instruction to appear for the sole opposite party.
हाँ अभी इंस्ट्रक्शन में जो अच्छी दियो दूरा
I will file the power, my lord, by tomorrow.
Similar matter.
Lords will direct my lord to solve a copier so that this case can be disposed.
No, it's all right. What is the good name?
N.R. Rautray, my lord.
N.R. Rautray. Mr. Nirmal Ranjan Rautray, it like you. Item number 7. Mr. Nirmal Ranjan Rautray, Land Council, submits that he has instruction to appear for the opposite party, Rudra Narayan Mishra.
My lord.
And he will file Vinama within
By tomorrow, my lord.
by tomorrow. Let a copy of the writ petition be served on Mr. Rautray by the next date. Put up this matter after Puja available. Here. Indicating the name of Mr. Nirmal Chandra Rautray.
Nirmal Ranjan.
Nirmal Ranjan Rautray in the false list. Here.
Obliged.
Item 8.
May I please, yours? Here in this case file for this Sukhtel project at Balangir, the entire village has been acquired by the executive engineer. And compensation so far the trees are concerned, my lord. Your losses page 17 or losses may kindly have a glance.
17.
My lord. That is for 8 years, my lord, for the mango tree. Your lordship first is the mango tree. Pholovhoki chaso manako ekok doro, my lord. Your lordship that is 3,960 mile. Calculating that, my lord, they have paid the
8th year mane kaun chila?
8 ବର୍ଷ ଯୋଉ
age of the tree. ସେମାନେ age of the tree
Age of-
ଟାକୁ definitely consider କରିକି ସେ ଅନୁସାରେ compensation ଦେଇଛନ୍ତି.
So how it is
According to his-
determined that's what is the age
that, my lord, they have they have determined, my lord, and thereafter they have calculated. For which, my lord, I filed the objection, my lord. They
No,
have
what is the
paid for-
method? What is the method that this tree is this month, this year?
Earth ତାକୁ ଦେଖିକିରି କେମିତି ମାପିକିରି କେମିତି ତାର
ଆଜ୍ଞା, ସେଇଟା
calculation
ତାପରେ
ଅଛି.
ମୋର ଇଏ ପରେ ସେମାନେ ମାପିଲେ ଆଜ୍ଞା।
ଡିସ୍ପ୍ୟୁଟ କରୁଛନ୍ତି ନା
ଆଜ୍ଞା, ତାପରେ ସେମାନେ ମାପିଲେ
ଆପଣ କହୁଛନ୍ତି ଏଇଟା ହଉଛି ଅଧିକା ବର୍ଷର
ଅଧିକ ବର୍ଷ ଦେନ୍ ମାପିଲେ ଆଜ୍ଞା ସବୁ।
ନାଇଁ ମାପିଲେ ନାଇଁ ଆପଣ representation ଦେଲେ your representation was considered and a report has also has come under annexure 4
Annexure 4
ଯୋଉଥିରେ କି କୁହାଗଲା ଯେ ଆପଣଙ୍କୁ
ଏଇଟା
ଏଇଟା
10 years, my lord।
ଏବଂ ସେ ଅନୁସାରେ
ମତେ
annexure 5 ଟା ହେଲା
ଆଜ୍ଞା, ମତେ କିନ୍ତୁ ପଇସା ଏପର୍ଯ୍ୟନ୍ତ ସେ 2 ବର୍ଷ ଆଜ୍ଞା ଦେଲେ।
Five ରେ
That is
ସେମାନେ
my
decide
grievance, your
କରିଦେଇଛନ୍ତି at ଯେ ଆଉ ଟିକେ ଅଧିକା 10 years ନେଇଛନ୍ତି. Initially it was taken for 8 years old. He was claiming for 12 years. They have taken it for 10 years.
So you have not been paid the compensation.
compensations for that differential amount.
So this item, this page 25 is
Page 25, my lord,
the signatures of the villagers are there
ସେମାନେ ମାପନ୍ତି ସବୁ ଗାଁ ବାଲାଙ୍କୁ ଡାକିକି
in presence of all.
in presence of
So thereafter, have you submitted any representation or
I have filed several times. I have gone the office, my lord,
No, no,
because the
sir.
entire
Annexure 5 ପରେ ତ ଆପଣ ଗୋଟେ ଦେବା କଥା.
I have
ସେମାନେ ତ
filed,
decide
my lord, but
କରିଦେଲେ.
as my lord, the receipt is not with me, my lord. That for that I have not annexed, my lord. Twice I have represented, my lord. for that.
But once they have decided under annexure 5
My lord, they should have
on the
paid-
basis of your representation
because
that
everything
it's
has been, my lord,
approved and-
after that project, my lord, we have lost everything because of the
all right,
entry of
okay.
water, my lord.
question is that they have already passed an
Yes,
order
yes.
in your favor
My lord,
that it is to be calculated taking into account that it is 10 years.
10
right?
years, my lord.
So for that, you said
And they
that
were-
you have submitted any representation after that.
Twice, my lord. But I have not annexed because
Oh.
that receipt was, they have lost that receipt, my lord.
Okay.
So you
So why
made a
don't you
fresh
file fresh
Yes, your lordship, please, my lord, with all these
with the
documents.
copy of this writ petition? so
With
that
the
it can-
stipulated period, they may consider.
Look, this writ petition has been filed by the petitioners with a prayer to pay the differential amount of the fruit bearing trees which has been acquired by the opposite party for which project it is?
Lower Sukhtel project, man.
So and so
Sukhtel
project.
irrigation project.
lower Sukhtel irrigation
Sukhtel irrigation project.
Balangir.
Balangir. The land council submits that though initially the assessment was made that the plants were of 8 years,
8 years.
but on inquiry it was found that the age of the plants was 10 years. And accordingly, the assistant horticulture officer Hoisinga, as for later dated, is it 1/5/23 or
That is my lord,
1/5/23.
1/5.
under Annexure 5 series 1/5/23 लिखा है.
1/5/23.
Communicated the same to Deputy Director Horticulture Palage. He is opposite party number. He is not a party here. No.
My lord,
No. It is you three considered.
The Land Council submits that in spite of such communication being made, the opposite parties have not yet paid the differential amount. According to him, the petitioner is now entitled to get rupees 8,430.
my lord,
As per the joint verification report, though he was paid only rupees 3,960.
my
The Land Council submits that after the later dated so 1/5/2023, though the petitioners submitted some representation, but the authorities have not considered the same. However, the petitioners are not having any document with them to show that when such representations were submitted before the authority, and therefore the petitioners may be permitted to file a fresh representation annexing the relevant documents to claim the differential amount towards the fruit bearing trees which has been acquired.
mango trees will also specify mango trees matter.
Before the
Mango trees.
mango fruit bearing tree bracket level mango. The Land Council for the state has no objection. It is in view of the submission made by the Land Council. If a representation is made by the petitioners before the Kapaku debe.
Land acquisition officer.
That is opposite party number 3.
3 my lord.
3.
3 November dita apna likh dijiye.
Sorry my lord, 4 of
opposite party number 4 special land acquisition officer lawyer Suktel project so and so है ना, within a period of
5 days my lord.
Within a period of 2 weeks करते हो ना. The
1 week lords.
ना 2 weeks telle आपण दे दियंतु 1 week.
Within a period of 2 weeks from today, with the copy of the order and a copy of the writ petition, the opposite party number 4 shall consider the same and communicate the order, pass necessary order, keeping in view the report of the assistant horticulture officer Loisinga, and if the petitioner is entitled to get the same shall be disbursed immediately, preferably within 2 weeks from the receipt of the representation from the petitioner. Accordingly, the writ petition is disposed of.
Okay.
Item number 10.
May I please, Your Lords? That the petitioner, before your lordships, with a prayer for a direction to the opposite parties to include him in the old petition rules. As per the advertisement under Annexure 1, he was joined as a junior clerk on 15/9/2005. That is before the much before the amendment of rules, my lord, by notification dated 31/8/2017 and amendment on 17/9/2005, my lord. Several petitioners of the same advertisement, my lord, they have approached before this honorable court, and this honorable court has disposed of this in the light of Ananda's case matter.
Anyway, finally, that government has also accepted.
Well,
under Annexure 3.
Well, now you have submitted a representation.
Well, that has been submitted to my authority, and that response to Annexure 6, the government has stated, like given a letter to the London District Judge Cutter, page 24.
Any order similar passed or
well, of the same advertisement, my lord. My lord, in WPC number 32669 of 21.
Let's take the implementation ବର୍ତ୍ତମାନ ସେ କହୁଛି restoration migration of OCS ତାକୁ ଦିଆହେଇଥିଲା MPF ଥିଲା ତାକୁ old condition ଦେବା କଥା କିଛି condition ରଖିଛନ୍ତି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଏଇ undertaking ଦେଇଦିଆ so the district judge is only inviting reference to subject matter. I am directed to say that the following information in favor of Srimati Swapna that may please be furnished. These information have already been furnished by you.
My lord.
Under Annexure 6.
Annexure 6 is the letter of the government to the London District Judge, my lord. I have my representation at
that is what is required. Some requirement is there for you to comply.
My lord, it's
we complied it.
In Annexure 6, my lord, they have required, my lord, to letter.
Any direction, order,
my lord, any direction, my lord. That was needed. Any direction, order of the Honorable High Court in support of the matter. My lord, in WPC 3269, the applicants and the present petitioner are of the same advertisement, my lord.
So you mean to say that your case is covered by that?
Kindly, since Annexure 6 is already there, let it be complied and let a decision be there, taken there also.
नहीं से ये जो फास्ट पैराग्राफ तो अच्छी तो any direction or order of the so and so in support of the so and so এটা বোধে
সেটা সেই আনন্দাস কেস রে দেবে
হ্যাঁ
সিমিলার কেস করে দেবে সেম অ্যাডভার্টাইজমেন্ট তো সেটা otherwise the sequence of events what my learned friend says appears to be correct but because advertisement recruitment both prior to 17/9/2005 only thing is that this advertisement is not annexed here. That would have Marot should have had Marot would have been seen that and would have passed it.
A direction में
All my lords say that it is applicable. Give me one chance. If my lords will pass that order that it is applicable,
then it is only because they have joined before the amendment.
Yes, that's why I said sequence of
and that is how it is in the covered by Ananda's case. Otherwise, who has joined beyond the notification, things would have been different because it is the same covered case.
Yes.
So we'll pass that.
As my lords.
Thank you. All right, yes.
Privileged.
Item 11.
Item, my lord, on behalf of Mr. S.S. Kashyap, I pay for adjournment.
Mr. Kashyap, you are not audible. Kindly submit loudly.
My lord, on behalf of Mr. S.S. Kashyap, my lord, I'm paying for adjournment.
Adjournment?
All right.
My lord.
After the holidays.
Yes. Item 12.
I have come.
Here. Item number
6. The rules are actually rules कहला 45 in aggregate और 33 होची Then you have secured 53. 53. You have got? No. Then मैं ସେଥିରେ ଆମେ ଏଇଟା ଇଣ୍ଡିଭିଜୁଆଲ ପେପର ପାଇଛି ନା 53% ଏଥିରେ ଇଣ୍ଡିଭିଜୁଆଲ ପାଇଛି ମୋର 5 ମାର୍କ ସଟେଜ ହଉଛି ନା ଏଗ୍ରିଗେଟ ହଉଛି ନା ନାଇଁ ଏଗ୍ରିଗେଟ ରେ ମୋର 45 in aggregate 45 in aggregate and 30 per paper ହଁ ହେଲେ your paper is it is per paper
33 ହେଇଯାଇଛି
ମୋର ଇଣ୍ଡିଭିଜୁଆଲ ପେପରଟା ଫାଇନାଲି ମୋର ଦରକାର ହଉଛି ଯୋଉ କଟ ଅଫ ଡେଟ୍ ଧରା ଯାଇଛି ସେଥିରେ ଆଉ 5 ମାର୍କ ମୋର ସର୍ଟେଜ ହଉଛି ନାଇଁ ଫାଇନାଲି ଏଥିରେ ମୁଁ ଯୋଉ ଫାଇନାଲି ସମସ୍ତଙ୍କୁ ଯୋଉ କଟ ଅଫ ଡେଟ୍ ଯୋଉ ମାର୍କ ଧରାଗଲା ସେଇଥିରେ ମୁଁ ଯୋଉ ଯିବି ସେଥିପାଇଁ ମତେ 5 ମାର୍କ
ଆପଣ କେତେ ପାଇଛନ୍ତି କହୁନାହାନ୍ତି ବର୍ତ୍ତମାନ ଏଗ୍ରିଗେଟ ଟୋଟାଲ ଆସିବ ଏଇଟା ତ 53 ନା ଗୋଟେ ଇଣ୍ଡିଭିଜୁଆଲ ଗୋଟେ ସିଙ୍ଗଲ ପେପରରେ ପାଇଲେ
repression para 3 नहीं para 3 para 4 पेज नंबर 3 मतलब पेज नंबर 3 paragraph 5 total 385 she secured 94 marks no what is the mark you have secured 94 86 78 all right we cannot now go by that no that that I convey because to appreciate my lord the kind of student I am. No, that has nothing to do. She was awarded 53 marks in law property in this individual subject, which prevented her from qualifying for the main written exam. So she failed to eligible for the round of examination. By obvious, 5 marks only the requirement.
ये तो ସରିଗଲାଣି ବୋଧେ
ହଁ ଏଇଟା ତ ରେଜଲ୍ଟ ବାହାରି ଯାଇଛି ଏଇଟା ତ ସରିଯାଇନି ନା ରେଜଲ୍ଟ ବାହାରି ଯାଇଛି ଏଇଟା ତ ଆର ବର୍ଷର ନା
ଆର ବର୍ଷ ହେଇଛି
22 23 ଆମେ ତ ଯୋଉ ଆମେ ଏବେ ସିନା ଚାଲିଲା ମୁଁ ତ ସେଠୁ କରିଛି ଆମେ ଯୋଉ ଆପ୍ଲାଏ କରିବୁ ଆନ୍ସର ସ୍କ୍ରିପ୍ଟ ଆପଣ ଆନ୍ସର ସ୍କ୍ରିପ୍ଟ ଦେଲା ମତେ ସାଙ୍ଗେ ସାଙ୍ଗେ
ଏଇଟା ତ ନେକ୍ସଟ ଇୟର କୁ ମାର୍ଚ୍ଚ କରି ଯାଇଥିବ
my lord that is there even in my case also Pragya Lalit Mishra versus OPS Miller that is also for 2 years I got the benefit of 2 years after 2 years even after exam I got it that is by this honorable court that is the decision of this that is
ଏଇଟା ଆମକୁ ସାଟିସ୍ଫାଏ କରନ୍ତୁ ଯେ ଆପଣ ଏଗ୍ରିଗେଟ ରେ ଯଦି 45 ମାର୍କ ରଖିବେ ତାହେଲେ ଆପଣ ମେନ୍ ଏକ୍ସାମିନେସନ ପାଇଁ କ୍ୱାଲିଫାଇ କରିପାରିବେ The commission shall call for the candidates from among those who have secured not less than 45% of marks in aggregate and minimum 33
in individual each paper
in the main written examination for interview. ତେଣୁ ଏଇଟା ହଉଛି ଆପଣଙ୍କର ମେନ୍ ରେ 33 ଏ ପେପରଟାରେ ରହିଲେ କିନ୍ତୁ ଆପଣ କହୁଛନ୍ତି ଏଗ୍ରିଗେଟ ରେ 45 ଆପଣଙ୍କର ହଉନାହିଁ ମାର୍କସିଟ୍ ଆପଣଙ୍କୁ ଆସିଲେ ଦେଖିବା
ମାର୍କସିଟ୍ ଏଇଟା ହଉଛି annexure 3 64% ଯୋଉଟା ଦିଆଯାଇଛି ସେଟା ତ ପ୍ରିଲିମିନାରୀ ଏଇଟା ହେଲା 94 86
ଆପଣ you come to annexure 3 preliminary examination ଆପଣଙ୍କ ହେଲା 64.10%. We are not concerned with that. We are concerned with this main examination.
Preliminary examination 64 point then this main exam
जनरल इंग्लिश रो फुल मार्क केते ए जो पाई जदी मेन रिटेन
150 सब
सब
150 सब 150
150 हेले
इंडिविजुअल 33
इंडिविजुअल 33 तो सबुतरे ही जाउची प्राय बोधे
से कट ऑफ मार्क 5 hello to remove the Max Miller may
1 2 3 4 5 पांचटा पेपर जदी हला टोटल मार्क त माने हला 750 ठीक तो 750 रो 45% केते आछी
इला ना से बाबा से हम एथे कथा देखछि से कहले हम लिखि बहुत किछि समथिंग
that calculation should have been there in the rate.
रिपीटिशन आपण कैलकुलेशन करया था
डिटेल टा देइथिले सेटा आपण जणा पड़तंता टोटल एटा एतिकी होची एटा हला एतिकी तेनु एतिकी हला एटा हबो
338 total. Year of 380.
35 हो
338.
338
338
आपण हिची केते
केते हिची 94
45 in agreement
86 plus 74 plus 53 plus 78 एदी तो हो
385.
हिची
385.
ना ना आपनकर हिची 385 दरकार केते
500 आतेला
ना ना फेर सेटा अरे आपण यू कम टू दैट हाउ कैन यू
338 ले हम केते होला आप 45 ले केते दरकार हो
then it is not calculation is not calculation କରନ୍ତୁ calculation କରିକି
कैलकुलेशन करन भलो के आपण देखंदु
ଏଇଟା ହିଁ ଅଛି
ए जो
2 ଅଛି
पेपर 1 टा पेपर 1 टा होची जनरल इंग्लिश
नहीं
जनरल इंग्लिश होची 150 मार्क
मेरा शॉर्ट अर्जन में
पेपर 2 रे आसिला प्रोसीड्यूरल लो
150
150 ला 300 आ ऑप्शनल पेपर को आपण तीनटा बाछियो पड़े तीनटा रे आपण पाइबे 450 हमने समुदाय मार्क को 750 हला 750 रो
385 is required no 385 is the 338 is required
apart from that each paper at least 33 ro
Sita, that you have to explain in detail in the read petition then only we can know
33
taken after lunch I'll give you
after lunch तो नहीं
tomorrow
आपण हिसाब करके मोर कागज रे दे दो
I now understand
याको एको देखि के नहीं हमें देखिबारे टोटल मार्क होची 750
I get you
750 रु आपण जदी 45% होची क्वालिफाइंग मार्क आ इंडिविजुअल पेपर 33 माने आपण सब पेपर पाई जाई जंदी बटन खाली दरकार आपण इंडिविजुअल ए जो एग्रीगेट रे 45 पाइबा
ओ सेट
is item 15 minor
no
so just
item 6
sorry
yes
on the request of the Grand Council for the petitioner put up this matter to them
as pattern
खाली तो आसी
हां
next
Annex 2 minor that was passed under 7(3)(a) of the OGLS Act by the petitioner prior to passing that order has purchased the land, but no notice, nothing. Petitioner is not hard minor. Annex 2 running to 16.
So there are other provisions. Have you come in the read?
No.
This is under OGLS.
OGLS.
Yes.
No appeal is provided. It's a division order. So much division.
Division by? ADM. 7(a)(3).
You are the opposite party in that revision petition.
No, original lessee. Magugai is the lessee, and he was made as the opposite party, and he was noticed, but he already lost his interest by annexure 1, that is on 6/2/96.
No, you come to that imprisoned order, page number 16. See the first subparagraph.
My lord.
Notice has been duly served.
So the
Opposite party is present.
So just first paragraph, my lord. Just after first paragraph.
Yeah.
1, 2, 3, 4, 5, 6, 7, 8 line. 8 line. Bhubaneswar in favor of Magugai Pai, son of Hangigai Pai, hearing after called as OP.
So who are you?
I am the purchaser. I have to inform the order. The no notice was sent.
Purchaser of what? Lease of land.
That lease plot I purchased. That is our next order.
This order has been passed long back in 98. How is that you are coming at this stage?
This is the expected order, my lord. The code is already passed, my lord.
When you purchased the land?
96. 96. 6/2/96.
Have you mutated the land?
No mutation.
Then how can the authority will know that it has been transferred to somebody?
22 permission is taken, my lord.
On the record, suppose X name is there, so they have issued notice to X, and X was heard and no order was passed. The authority was not aware that X has in the meantime sold the land to Y. If you say that you purchased the land from X in 1996, then it was your duty to mutate the land. That has not been done. What is the fault with the authority if they are not aware, or let us say that man did not disclose before, even he appeared, he did not disclose to the authority that I have already sold the land to Mr. Y.
The similar coordinates.
What happened? Where is the document to show that this very document?
Annexure 1 is the arrest, my lord.
When it was executed?
6/2/96.
Please show that date.
No, that is the running page 15.
1/5.
1/5.
Let us see that.
Last person 6/2/96. 6/2/96.
So the question, the ground on which this has also been refuted is the ground of fraud.
Fraud, no, that's clear. What is the terms and condition of that lease?
Within 10 years, it should not be sold without the permission. 52 permission has taken, my lord, because the lessee is a civil tribe.
When the lease was granted in favor of?
That is
in favor of that Magu.
My lord, that is 73. 262. WL case number 262 of 70. In the intent it was reflected.
Actually lease 70.
70. 262 of 70. WL case number.
What similar order you say that?
Set aside and remitted to the regional authority to decide to address, taking the
This date is a genuine date. That cell deed was registered. We do we do not know that.
That mirror. And it is in 98. Let him approach, my lord, with this order.
ऊपर लिखा है ट्रू कॉपी होची लिखा है 24/1/2000
सर्टिफिकेट टोटल होची कि ना एटा हमर अंडर वैल्यूएशन हेतला मो अंडर वैल्यूएशन पैसा भी देछि अंडर वैल्यूएशन हेतला तो अंडर वैल्यूएशन पैसा एटा बर्तन दैट इज द रिसीट मैन्युअल
use word say now ଗୋଟେ opportunity ଗୋଟେ ଦो ତାପରେ ଦେଖି
give me one. I will give me a short adjournment. Find out.
ए registered cell deed ର date जा ଯଦି genuine ଥିବ ତାହେଲେ ଆଉ କିଛି
And
ଅସୁବିଧା
that
ନାହିଁ
too, my lord, sir, aware that these exercises were being carried out pursuant to the direction of this honorable court.
I know that.
So,
but ultimately he has a right to be heard. He can do it on the ground of law. It is not that he should not hear the party. ତେଣୁ ସେଠି ସେମାନେ ଯଦି ସେଲ୍ ଡିଡ୍ ର ଡେଟ୍ ଟା ଦେଖିବେ ଯଦି ଇଏ ଥିବ ତାକୁ ଶୁଣିକିନି କାରଣ but we see that on this ground they are not interfering, they are just keeping it like that. God grounded. This petition has been filed by the petitioner Ajay Kumar Rao, right? For setting aside the order of the ADM Khurda dated 21/4/1998 in cancelling the lease granted in favor of Magu Gai Pai in case number is
WL case number 262
case number 262 of
1970.
By the government in respect of acre 1.000 out of Sabik plot number 67 under Sabik Khata number 237 of village Simli Patana, PS Chandaka in the district of Puri, now Khurda, by Tahsildar Bhubaneswar. The Laden Council for the petitioner submitted that the petitioner purchased the land from the lessee Magu Gai Pai on 6/2/1996, and the revision case was instituted in the year 1998, right? Revision case number 8 of 1998, and neither any notice was served on the petitioner, nor he was given an opportunity of hearing. And on the basis of service of notice on the lessee Magu Gaipai, the impugned order dated so was passed and the lease granted in his favor was cancelled. Land Council so submit that the petitioner is necessary party, and since the petitioner has not been served with a notice, the order is not sustainable in the eye of law. And therefore the petitioner may be given an opportunity of hearing. Land Council for the state opposed the prayer for bail. Opposed the on the ground that the impugned order was passed on 21/4/1998, and in the meantime, more than so and so years have passed. The Land Council for the petitioner submit that he was not aware about the order passed. Be that as it may, let the petitioner be given an opportunity of hearing to place his case before PM opposite party number 2, and in case he files his application within a period of 4 weeks from today, the same shall be considered in accordance with law. If it is made clear that if after hearing the parties, the opposite party number 2 decides to cancel the lease granted in favor of Magu so and so, which was transport so and so, he is at liberty to do so. We have not expressed any opinion on the so and so. The order is passed only on the ground that the opportunity has not been provided to the petitioner while disposing of revision case number 8 of 1998. Accordingly, the petition is disposed of. Yes.
Item 13.
Yes.
That's 12 minor.
Item 15, we didn't receive the copy of the petition.
13.
Indian Railway New Party.
Mr. Party, what do you want?
Item 15, this Indian Railway New Party. We didn't receive the copy of this.
We are in 13.
Mr. Party, we are in item number 13. 1 3.
Oh, sorry. I got it.
Item number 13.
Page 12. I am owner of a 16 decimal of land.
What is your prayer in this application?
The dispute is the same plot was acquired by NHI and the same plot was acquired by the Konya coal mines. Both the acts are, it is under the National Highway Act, that is under the Coal Bearing Act. I am giving one. My plot number is 6043391.
Yes.
It is 8 decimal. 6043399. It is 8 decimal. My lord, the notification of NHI. Page 15. Serial number 72 and 73. I have got it.
Plot number 604/3391.
Yes, 6043391. That was acquired by National Highway 8 decimal. Ghorawadi is 2 decimal. My lord, page 17. The Mahanadi coal field also acquired the same plot. Page 18, my lord. My problem is that my lord, they have the Mahanadi coalfield is giving me 6,15,966 rupees only. Whereas the NHI for 2 decimal of land has calculated 31 lakhs and some more. Whosoever takes the land, I have no objection, but I should be giving compensation, due compensation.
No. In the event the your land acquired under the coal bearing,
yes,
then you have to raise the claim before the commission.
No, I had to raise my lord page 21. That was also my lord's direction.
Yes.
That is, but if I get that NHI, if he takes the land, NHI, that is the special act. Once the NHI takes the land, that cannot be taken up by the coal mine, by the coal bearing or any of the NHI is to NHI special act is to acquire the land. So it is the dispute between the two NHI and the coal bearing and the coal mines.
You said that they have acquired only part of
that
plot. It's not the entire plot.
No, my lord, coal bearing act total side ani ହେଇଛନ୍ତି. Page
17. 18 ne jota achi.
Page 18.
କୋଉଠି ଲେଖା ହେଇଛି?
So
16 decimal. 8 16 decimal. ଆଉ ସେଠି କେତେ ଅଛି ଆପଣଙ୍କର?
ସେଠି 16 decimal ପର. Page 12. Page 13 ହଉଛି 16 decimal, total 16 decimal.
91 ରେ 4 decimal, 8 decimal ଅଛି. 8 decimal ଅଛି ବୋଧେ?
18 ଏଟାର 8 ସେଟାର 8 ଦୁଇଟା ନାକେ 16. 13 ନମ୍ବର ପେଜରେ ଏଟାର 8 ସେଟାର 8 ଦୁଇଟା ନାକେ 16. ମୋ ଟୋଟାଲ ଜାଗା ହଉଛି
16 decimal ଯାକ ଇଏ acquired କଲା MCL. That is
they are giving me 5 lakhs only.
So what has happened now?
But they are not, because of this dispute, inter-dispute, I am not getting the compensation. Whatever, whosoever takes that, it is mining, Konya mining or NHI. I shall get that my compensation, but I am not getting compensation because of the dispute.
You have made both of them party?
Both of them, yes, my lord.
NHI, that is item number 1, serial number 1 of the
yes, my lord.
And the others are 3, 4 and
Mr. Bansal 4.
Achha. Who is appearing for any NHI? Amitabh Das used to
NHI.
Who is appearing? Any counsel is there for Mahanadi Coalfield? Mr. Mishra, Mr. Das, retainer.
MCL ପାଇଁ ତ
panel କିଏ କହୁନାହାନ୍ତି?
ରାକେଶ ଶର୍ମା ଜଣେ
ରାକେଶ ଶର୍ମା
ୟାଙ୍କର ହେଲା ଅମିତାଭ ଦାସ,
ରାକେଶ
ଶର୍ମା
MCL.
Copy issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. It is stated at the bar that for NHI, Mr. Amitabh Das,
I am solving copy.
Needs to appear. A copy of the writ petition has been served in court on the associate of Mr. Amitabh Das, who wants to obtain instruction. It is further stated that Mr. Rakesh Sharma is the counsel for the Mahanadi Coalfields Limited. Let a copy of the writ petition on the Land Council for Mahanadi Coalfields to obtain instruction in the matter. Matter be placed after ensuing visa holidays. Yes, indicating the name of Mr. Amitabh Das and Rakesh Sharma in the cause list.
Item 13.
May I please your lordship? I am a victim, my lord. The petition has challenged the order lease application of the petitioner by the answer 12 of the writ application, my lord. The lordship may kindly see page 28 and page 12, my lord. Sorry, page 30, my lord, answer 12. Into page 32, my lord. Page 32, my lord.
Yes.
And whereas there are no provisions in the Odisha Government Land Settlement Second Amendment Rules 2020 for settlement of the encroached land in the capital city, the aforementioned land is a valuable government land which can be put to various alternative uses for the development and public purposes of the capital city, my lord. That is the order, my lord. The petitioner applied for lease in the year 1991, my lord. The opposite party number 2 has sent a letter, my lord, to supply all the required documents for settlement of the lease, my lord. In the year 92, my lord, the petitioner supplied all the documents, my lord, but they did not consider, my lord. So the petitioner filed a writ petition for lordship, and the lordship directed them to consider the matter within 4 months and pass the necessary order and send the same to the petitioner, my lord. But they did not send. The petitioner filed a petition for contempt, my lord. And your lords, in the contempt petition, my lord, at Annex 11, my lord, page 28, my lord, your lordship may kindly see page 29, my lord. Your observation of your lordship, my lord. Page 29, my lord. In such a view of the matter, the contempt proceeding is dropped with the observation that the petitioner shall be at liberty to question the correctness of the order dated 2/11/23 passed by Chief Secretary, GA Department, Government of Odisha, my lord. The order he has passed in my behind me, my lord. They have not communicated the order, my lord. I have got it by RTI Act, my lord, and challenging it before the lordship. They have to consider my application and grant the lease, my lord. It is not in Bhubaneswar city, my lord. It is in Nuaga near Samataraipur, my lord.
No, but you say that the land has been enclosed.
I have not enclosed, my lord. Since they
No,
have
that is your case that they have encroached upon the land. Where is the question of adjudication in the writ?
That is there. They say what they say, my lord. I have not enclosed, my lord. They have asked me to supply documents. I supplied all the documents with the building plan, my lord. Then said you start functioning still election industry and we will consider your case, but they did not consider. So I apply your lordship. They have illegally rejected my order, the application, my lord, and your lordship directed the correctness of the order that shall be questioned in another case, my lord. That is why I have filed the case, my lord. Let them file a counter and say how they have rejected my that amendment rules is also not available in the book, my lord. Let them file the counter affidavit saying legal.
So if you come to page number 32,
my lord,
that is the later,
my lord,
the
my lord,
additional chief secretary,
my
you
lord,
find in the first paragraph it is mentioned, please press that matter.
my lord, my lord.
Whereas,
on verification of
yes,
the field submitted by the revenue authorities, G and PD band, it is seen that 5 numbers of administration houses deviating the approved building plan exist over the shown plan unauthorizedly. The same administration houses are being used for commercial purpose as a mobile and accessories. Subha Lakshmi Auto Works and Mrs. MP Stilex. MP Stilex is my industry, my lord, and food stand is there, my lord. So, and whereas they have already seen that the food plant has been illegally and unauthorized occupied by the petitioner and others, my lord. And where there is no provision in the Odisha Government Land Settlement Second Amendment Rules 2020 for settlement of the enclosed land in the capital city. Land is a valuable government land which can be put to various alternative uses for development and public purposes of capital city. Being developed, the petition is rejected.
So you want the land for settlement of the purpose of SSI unit.
My
Now
lord,
you are in unauthorized occupation of that land. They have
my lord,
stated that there is no provision,
Yes.
so and so, for settlement of the enclosed land in the capital city.
my lord,
That is a very valuable piece of land which can be
my lord,
put to various alternative use for developmental and public purposes.
my lord.
So what is the fault in the order so that we will interfere?
Under section 3 and rule 5 of the Government Land Settlement Act, my lord, they have to provide me, they have to approve the lease in my favor, my lord. But they have not done so, my lord. But
No,
this amendment,
anyone who is unauthorizedly occupying a government land, they has to be given that land. That is your contention.
no, that I don't know. But
No, that is your case here. You have been in possession of a particular land and you want the government to settle it in your name. You can make an application independent of that, seeking a piece of land under the act.
Any suitable land is available,
But you cannot make it.
a particular, which is a valuable piece of land, you have unauthorizedly occupying it. You have opened the MP Steelex Industries there. So enjoying that land. Now you filed an application for settlement. They said that this cannot be done. So what is the illegality in that?
But I have applied in 1991, my lord. And 92, they have given letter to send all the
When you applied is not the question, sir. How did you occupy the land? What is the mode of occupation of the land? Mode of occupation of the land is encroachment, unauthorized.
My lord.
And you insist upon the government to settle that land in your favor. So one fine morning I will go to a place, unauthorizedly occupy that area, and later I ask the government to settle it in my name. How can it be so good?
It is not in rules or
If you prove for, you have been saying that you are in position since 31 years, you can go for civil suit if you like.
I am in position and I am
Or the Land Council for the petitioner, Land Council for the state. The writ petition has been filed by the petitioner Sarosh Kumar Mishra with a prayer for a permanent lease deed or sale deed to be executed in his favor by the government in respect of Khata number 452, plot number 146, Mauja Nuaga, area Ekorsun 44, bracketed 1900 square feet out of Ekor 2370 near Samantrapur, Bhubaneswar for industrial purpose. The Land Council for the petitioner submitted that the petitioner is the managing partner of Messrs. MP Steelex Industries with a small-scale industrial unit being registered under District Industry Center, Puri. And this unit was set up for a government land located at Sauntarpur since 1982. And the petitioner submitted a letter to the opposite party on 11/12/1991 for allotment of a piece of land for the registered SSI unit at Sauntarpur. And the opposite party in its reply by letter dated 23/3/1992 asked the petitioner to furnish a detailed plan and scheme along with the source of income for taking further action in that regard. The petitioner also submitted the working plan with case map and other documents to opposite party on 26/9/1992, but thereafter no action was taken. And when the petitioner submitted a representation on 19/7/2023, and when the same was not disposed of, the petitioner approached this court for suitable direction, and as per the direction of this court, the representation has been disposed of, and the in the improved order dated 2/11/2023 passed by the government, it has been held that since the petitioner, the suit land has been illegally and unauthorizedly occupied by the petitioner, and there is no provision in the Odisha Government Land Settlement Second Amendment Rules 2020 for settlement of the enclosed land in the capital city, and that the land in question is a valuable government land which can be put to various alternative uses for developmental and public purposes of the capital city. Therefore, the prayer of the petitioner for settlement of the government land in his favor for the purpose of SSI unit being devoid of merits, and accordingly the same was rejected. The Land Council for the petitioner submitted that since the petitioner was in occupation of the land since long, and the government has the power under the Odisha Government Land Settlement Act 1962 for settlement of the land, and the petitioner is running an industry, small scale industries in the land. The rejection order passed by the so was unjustified. The Land Council for the state, on the other hand, supported the order passed by the authority. Considering the submission made by the Land Council for the respective parties, and after going through the this Odisha government land settlement and the impugned order passed, we find no illegality in the aforesaid order. Therefore, we are not inclined to interfere with the same. Accordingly, the petition being devoid of merit stands dismissed. Yes, next.
Item 15.
Next.
Item 16.
May I please, guys? Here, the petitioner is the bank manager who extended a loan in favor of the occupant of court, pursuant to the NOC issued by the IDCO under Annexure 1, post 12 mallard. Since the land is a leasehold land of the IDCO, the NOC was granted by the IDCO that to mortgage that property against the loan will be available by the occupant of court. Accordingly, loan was available by the occupant of court and he did not pay the same. The pursuant to the securitization proceeding, the land was sold in favor of the occupant of 5 and 6. Now, when the bank wrote letter to the IDCO to transfer the land in favor of the auction. You can say Annexure 5, page 21. The IDCO wrote letter that it cannot be transferred as because the number of proceedings pending for this Honorable Courts also before the DRT. And the bank was called upon to submit a report. The bank submitted the report under Annexure 7, the detailed report. So far the restrictions are concerned, they are already split up, and only the second appeal is pending for this Honorable Court, where only notice has been issued and DRT essay is pending on behalf of the borrower. So no restraint order is there to prohibit transfer of the land in favor of the auction purchasers. About 2 years have been passed. The sale certificate has been issued. Physical possession has been handed over to the auction purchasers. Because of this letter by the IDCO, the bank is not in a position to transfer the land in favor of the auction purchasers. Detailed report under Annexure 7, you can see page 23. The report is submitted
Notice has to be issued in this matter, if you say. Notice has to be issued so many, and issue notice on the question of admission indicating there is matter will be disposed of at the stage of admission. Eman pai ki returner achandi to IDCO pai ki achandi na nai notice you. अच्छा, liquidated
And accepting notice for the auction purchaser, opposite auction purchaser.
Auction purchaser. So they are insisting in your favor.
And supporting pricing.
That
Yes.
they are insisting for you.
You enter
Yes.
appearance.
Yes.
So, whose name will record that here?
Shashwat Kumar Acharya for OP 5 and 6.
Mr. Shashwat Kumar Acharya and counsel submit that he has instruction to appear for opposite party number 5 and 6. Let him file Wakalatnama. The land counsel for the petitioner shall serve extra copies of the writ petition on the land counsel for the opposite party number 5 and 6 in the meantime. Speed post requisites for issuance of notice on opposite parties number 1 to 4 shall be filed within a week. List this matter after issuance. After, if any, be filed in a week.
Lordships are fixing this matter too.
Yeah.
After vacation.
Obliged, Your Lordship. You file your VNAMA, huh?
Yes, Your
He
Lordship.
will serve you the copy of the writ petition in the
We'll do that.
Item 17.
Item 17. Application under land acquisition and rehabilitation rules, my lords. The petitioner father was a displaced person on that Rengani Dam project, my lords. Also made a representation, my lords.
Annexure 2.
Annexure 2, my lords.
Annexure 2 to disposed of.
OP number 2, my lords.
Okay.
Published.
Item 18.
The recovery or exception that was made, your lordship last case had asked her to win the profit mercy case. In view of the principle decided, the opposite party forms within the class 3 and that is not permissible. I am passing on the judgment to your lordship. Para 12 page 704. Page 704, para 12 last part.
That also, you have issued that surplus. Second March 2016. That the Tribunal has also quoted that I have given the surplus.
Judgment है मध्य of तुम judgment उस आम के लिए शक्ति Page 2, that circular that are given by my friend. Para 4, recovery for employees belonging to class 3 and class 4 series, group C and group D service. Recovery for retired employees or employees who are due to retire within 1 year of the order of recovery. Recovery for employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is issued. Recovery in cases where an employee has wrongly been required to discharge. My lord?
Category
ये को कैटेगरी सी ना डी ये को कैटेगरी
क्लास 3 रे
क्लास 3 माने सी
क्लास 3 जो
क्लास 3 जोटा अच्छा क्लास 3 रे आछी
recovery from employees when the excess amount has been made for a period in excess of 5 years before the order of recovery is issued, right? Itira आछी कौन है लाता देने
my lord?
So your case doesn't cover this. Your case doesn't cover this. The judgment doesn't cover your case.
I am saying that recovery is not permissible.
That is what, according to you.
Yes.
No.
But one thing in this case is that the undertaking was given when pay was fixed. That even account of audit or for wrong fixation, Any amount paid, that is to be recovered. That is undertaking was given by the employee.
Where is that order? 6%. କେତେ ଟଙ୍କା ଏକ୍ସେସ୍ ପେମେଣ୍ଟ ହେଇଛି କହୁଛନ୍ତି?
2,67,000.
କେବେ?
67,000.
କେବେ ହେଇଛି?
2013.
ये रिटायर्ड कर सारे?
70 रिटायर्ड कर.
पास ହେଲା?
Hello?
Order of recovery କେବେ ପାସ୍ ହେଲା?
First order of recovery କେବେ pass ହେଲା? Before retirement, your pension paper were prepared. At that point of time, advice was given that you have to withhold this amount from his dues.
So that is before retirement.
That was all.
They have decided and with all the retainer benefits,
When he was at the time of demitting the office, by then he had not retired while settling his pension paper.
after retirement they have figured.
Within the amount.
No, it's order ଟା କେବେର?
There is no order.
Huh?
There is no order.
No, ହେଇଛି ପ୍ଲସ୍ କହୁଛନ୍ତି.
I am coming from. Advice was given.
ଆପଣଙ୍କର ଡେଟ୍ ଅଫ୍ ରିକଭରିକୁ ଯଦି 5 ବର୍ଷ ଟପି ଯାଇଥିବ ତାହେଲେ ହେଇପାରିବନି ବୋଲି ସୁପ୍ରିମ କୋର୍ଟ କହିଲେ.
And also my lord, since the crucial claim.
Annexure 3, my lord.
That's what as for one. So from an employee belong to class 3 and class 4 service. And he belongs to class 3.
Annexure 3 has paid 13 my lord.
Class 3.
And the group C.
Yes, ma'am.
Class 3.
Yes, ma'am.
That would be impermissible.
Yes, ma'am. Impermissible.
Which is last 3
not possible. Sort of through the surplus and also the judgment of the office.
All right.
And Annexure 3, the advice that was given by the department, we told them.
The petition has been filed by the so and so challenging the order dated 6/12/2023 passed by the Central Administrative Tribunal, passed in OA number so and so. With a further prayer to maintain the withholding order at Annexure 6. It appears that the opposite party, Dushman Kumar Paul, filed the original application before the Central Administrative Tribunal Court of Bench. Wherein he has agreed for a direction to the petitioners to refund /return the withheld amount of rupees 2,67,073 in his favor with interest. The opposite party was working as UDC and he retired from the service on reaching the age of superannuation with effect from 31/1/2017. And following his retirement, he was paid his retirement dues oblique pension after deducting an amount of rupees 2,67,073 from his gratuity towards the excess payment made to him while fixing his pay with effect from 1/1/2006. The London Tribunal relied upon the decision of the Honorable Supreme Court in case of State of Punjab versus Rafiq Mashia, bracketary whitewasher. The reported one. Yeah, 2015 Supreme Court 696, wherein it has been held that since the applicant was a Group C employee and recovery from his retirement dues would cause financial hardship, therefore he comes under the condition stipulated in the said OM dated so and so. The contention of the Land Council for the opposite party before the Central Administrative Tribunal was that he was a Group C retired employee and the excess payment is not on account of any of his fault and recovery from the gratuity is not justifiable in view of the decision of the Honorable Supreme Court in case of Rafiq Mashia Supra. And the OM issued by the DOPT dated 2/3/2016. The London Tribunal, after hearing the Land Council for both the parties, has been pleased to hold as follows. A to quote for the paragraph number 9 entirety. The Land Council for the Union of India submits that since the recovery was made within a period of 5 years, therefore it is permissible for the authority to do so. However, Mr. Devi Pratap Samant and his associates who have filed power for the opposite party brought to the notice of this court the office memorandum number such and such dated 2/1 and submitted that the petitioner's case, the opposite party case found within the first clause, that is recovery from the employee belonging to Group 3 is impermissible. Repeatedly, the opposite party, so and so, is a Group C, is a Class 3 employee, and he has already been retired from service, and his case is squarely covered under the principle laid down by the Honorable Supreme Court in so and so case, and therefore the London administrative tribunal has committed no illegality in passing the impugned order. After going through the contentions raised by the Land Council for the respective parties, the office memorandum dated so the citation since the petitioner is admittedly belong to group C and the uh, payment disbursement of this one so was not on account of any fault of the petitioner. Therefore, we are of the view that the London Tribunal has rightly held that the order of recovery is impermissible in law, and therefore the Tribunal has held that the action of the petitioners in effecting the withdrawal of rupees so had order dated so as bad in law and rightly passed the same and passed the order of refund of the same amount so. Since we do not find any merits in this petition, the same is hereby dismissed. The petitioner shall immediately refund the amount, withhold amount of rupees 2,67,073 to the opposite party within a period of 2 weeks from today. Accordingly, the petition is disposed of. Paper book here. More people. Yes.
Within list, item number 1.
As per your lordship's direction, I have also prepared a note, served copy on my land senior for the state.
on last occasion, my lord was kind enough to see the evidences and the prosecution case, my lord. I am not repeating, my lord. To refresh my memory, I am just placing few lines. My lord, the charge against the appellant is under 302-201, alleging that the appellant committed murder of his wife, Shashirekha, in the MLA quarter on 29/8/95. The prosecution case is the PW10, who was the SI of police attached to Kharbal Nagar, lodged a written report before the IIC Kharbal Nagar alleging that while he was investigating Kharbal Nagar PS case UD case number 6 of 95, it was registered on the basis of information of the appellant that his wife has committed suicide inside the closed bathroom of his quarter. He noticed that inner bolt of the bathroom was not tampered and there was no mark of any violence. The broken glass pieces of the ventilator of the bathroom was lying below the body of the deceased, and there was no mark of violence found on the wall of the bathroom, nor the articles of the bathroom were disturbed. During inquest and PM examination, it was found that the injury was on the back of the head of the deceased, which was antemortem, and the recent mark of injury was found, and the recent mark of injury was found on the dorsal side of the figure of the accused. Carbonyl hemoglobin could not be detected by chemical analysis conducted by the SFSL from the sample of blood of the deceased, and further it was mentioned that during course of investigation, the appellant was not pulling on well with the deceased, who was the second wife of the appellant, and both of them used to having fight among each other. This was the prosecution case. In the present case, my humble submission before your lordship is there is no direct evidence to that effect. It is completely based on circumstantial evidence. My lord, to prove the circumstantial evidence, I have raised 5 points basing on 1984 Supreme Court 1622, which was also noted down by the learned trial court at page 26 and 27 of the paper book. The circumstances from which the conclusion of guilt is to be drawn should be clearly established. The circumstances concerned must or should and not may be established. Second, the facts so established should be consistent only with the hypothesis of the guilt of the accused, that is to say, that they should not be explainable or any other hypothesis except that the accused is guilty. The circumstances should be conclusive in nature and tendencies. Fourth, they should exclude every possible hypothesis except one to be proved. There must be chain of evidence so concrete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that all human probability the act must have been done by the accused. Now, these are the guiding principles which has been laid down by the Honorable Apex Court in 1984 Supreme Court 1622, which was noted by the learned trial court. Now, your lordship may kindly see how the learned trial court decides the same. My lord may kindly turn to page 29 of the paper book, the fourth para. The IO, well, I'm sorry, my lord. The IO on 1995 made queries to PW9 to ascertain the mode of death of the accused as to whether it was due to asphyxia or due to the shock resulting out of burn, and to ascertain the approximate time of death. PW9 replied to such queries as that the mode of death was asphyxia and the time since death was 4 to 12 hours as mentioned in his report by Exhibit 9. He proved the query report of IO marked as Exhibit 10 and 10/1 in his answer. And Exhibit 10/2 is his signature in the answer report. The IO again on 4/9/95 made queries to PW9 to ascertain if the asphyxia was due to throttling, stroke strangulation, or suffocation arising out of the smoke produced by burning, and to ascertain if the cause of death was suicidal, stroke homicidal, or accidental. PW9 replied to such queries as that the mode of death was asphyxia, shock, and sunset, and was due to suffocation resulting from inhalation of smoke from combustion. The manner of death is not accidental. However, his findings was not conclusive to opine whether the death was homicidal or suicidal. He proved the query on of the IO, right? Exhibit 11 and Exhibit 12 as his reply, and Exhibit 12/1 is his signature in the reply. The learned trial court, in the conclusion at paragraph 14 at page 32. On an analysis of statement of PW8 and PW10, it can be gathered that if the wife of the accused committed suicide, then the instincts of survival would have been made her disturbing the things lying close to her, or she should have attempted to survive by running outside the bathroom and proceeding to the open space after opening the inner bolt of the bathroom, or by opening the water tap of the bathroom. In the instant case, the spot visit report, along with the statement of PW8 and 10, shows that the plastic bucket and plastic mug lying near the left leg of the deceased was found undisturbed. There is nothing on the record suggesting that the deceased ran towards the open space out of the bathroom after opening the inner bolt of the bathroom or had opened the tap of the bathroom. My lord, my reply would be my lord, if your lordship may kindly see my note at paragraph 8. I have tried to explain, my lord.
Yes.
My lord, may kindly turn to paragraph 8 of my note. I'm sorry, my lord.
8 or 8th.
Page 8, paragraph 8. My lord, I'm extremely sorry that I have not paid.
After paragraph 4, 5.
My lord, towards the last, my lord, paragraph 8.
You have not given the page number.
I'm sorry, my lord, that is my mistake, my lord. I have not. Paragraph 7, my lord, I have noted the principles laid down in 1984 Supreme Court.
Yes,
Paragraph
8A.
Yes. My lord, the learned trial court in paragraph 14 of the impugned judgment tried to draw conclusion on the following. A. PW8 and 10 statements pointed out that the deceased could have attempted to survive by running outside the bathroom. My lord, my humble submission is, this is the consistent evidence of the prosecution that there was no pouring of kerosene outside the bathroom. My lord, here in the present case, the prosecution has not made out a case that the appellant poured kerosene on the wife outside the bathroom. It was the entire incident had happened inside the bathroom, which was locked from inside. So they did not make out a case that the kerosene was poured outside the bathroom and fire was lit and so she ran away inside the bathroom. It is not the prosecution case. Moreover, there was no prosecution also did not make out a case that there was dragging of the deceased from outside to the inside the bathroom. The bathroom, if your lordship just visualizes, the entire incident happened within the bathroom. Outside the bathroom, there is a lobby in a MLA quarter. The prosecution did not make out a case that the pouring of kerosene was in the lobby and she was dragged inside the bathroom and the fire was lit. That is not the case. The door was locked, stroke bolted from inside the bathroom. Kerosene jar, matchbox, it is the prosecution case, was found inside the bathroom and there was no tampering of bathroom premises. Therefore, it can be safely concluded that the accused neither poured kerosene nor lit the fire and he was not instrumental in the death of the deceased. Because if the prosecution would have made out the case, my lord, that the kerosene was poured outside, she was dragged to the bathroom and the fire was lit, then, my lord, some material could have been against me. But here in the present case, the kerosene jar was found inside the bathroom, matchlight was found inside the bathroom, and the bathroom was bolted from inside. There is no, even the postmortem report does not make out a case that there was injuries on the back while pulling the deceased.
Why are you saying that it was taken place? Who has stated that it is not neither the case of the prosecution nor the case of the defense? That it took place outside and then he was.
No, my lord. Here the learned trial court says that once it is undisturbed and there was the bucket and the plastic mug was lying inside, the learned trial court proceeded on the notion as if the murder was committed before outside the bathroom. The learned trial court in paragraph 14, if your lordship may kindly see. Yes. Further, the statement of PW8 with the spot map, Exhibit 8 shows that there was uniform smoke deposit all over. The prosecution pins down the appellant on the ground that because they were undisturbed.
Where is it placing them?
On page 33 of the paper book.
Which paragraph?
On the second subparagraph. Further, the statement of PW8 along with the spot visit report Exhibit 8 shows that there was uniform smoke deposit all over the wall of the bathroom and on the bolt of the door, the bathroom indicated that there is no mark of violence found on the walls. If the wife of the accused committed suicide, then she should have dashed against the walls of the bathroom because the instinct of survival should have compelled her to dash against the wall, but there was no such mark of violence found on the wall. Par contra, DW1 claims that the wife of the accused committed suicide in the bathroom. On going through the statement of DW1, it is noticed that the evidence is self-contradictory. In para 4 of the statement, he has given the description of the spot house. As per statement, the spot house, including all the MLA quarters, consists of 5 rooms. There is one lobby in the said quarter. To the left side of the said lobby, one room was situated for the respective constituent people. After the said lobby, 4 rooms were there for personal use of the concerned MLA. He used the bathroom attached to the room meant for constituent people. The above description given by the witness about the quarters of the MLA, including the spot house, does not tally with the spot map, white Exhibit 15. The said spot map, Exhibit 15, is marked by the prosecution without objection from the side of defense. No bathroom is attached to the room where the constituent people stayed. Further, DW1 has stated that there are 2 ventilators in the bathroom, but PW10 has stated during his spot visit that he found the spot bathroom had 1 ventilator. Furthermore, it is noticed from the statement of DW1 that while he was using the bathroom, the wife of the accused, deceased, came there and told him to leave the bathroom as she would use the same. Soap, 1 plastic bucket, 1 plastic mug were kept inside the bathroom. The wife of the accused was wearing a sari and also brought one sari with her. It is further noticed from the statement of DW1 that he was cleaning his teeth at a distance of 10 to 15 feet from the said bathroom. He found smoke coming out of the skylight, but during his examination in chief, he stated that he saw smoke was coming out of the bathroom. He further stated, and they heard the scream of the wife of the deceased as Morigali Morigali. Hearing such scream, he rushed to the said bathroom, pushed the door of the bathroom and told to open the door of the bathroom. Then he proceeded to call accused. He found that the accused talking to two persons in the lobby. On his calling, the accused alone came. Though the aforesaid two persons came, but they did not try to open the door. In para 3, he stated that he ran towards the room of the accused and called the accused from his room. He did not tell about the presence of any two persons during his examination in chief. He further stated the smoke is only coming out through the skylight and it was not coming through the door of the bathroom. On his push, the tar bolt of the bathroom was broken. He found that the wife of the accused was lying towards the south side of the bathroom. The wife of the accused was burning. Fire was coming out of her wearing sari. At that time, she was found dead. But he brought a blanket from another room and put it on the body of the wife of the accused. In para 3, DW1 has stated that when he tried to extinguish the fire, his eyebrow and hair was burnt. During cross-examination, he has stated that he sustained one injury in the left hand finger. But during his medical examination by PW7, no such injury was detected on the left hand finger. There is no smell of kerosene coming from his body during his medical examination. However, it appears that after the burning of the deceased started, DW1 somehow came to know about the incident and arrived there, and while witnessing the burning due to impact of heat, his hair and his eyebrow would have been burnt. So the plea of this DW1 that he sustained such injury at the time of extinguishing fire of the body of the deceased appears to be not believable. Though DW1 deposed that he has put one blanket over the body of the deceased to put out the fire, but no such half-burnt blanket was seized during the spot visit of the IO. Though the IO seized burnt red saya, burnt blue printed sari from the spot while Caesar exhibit 5. So this plea of defense DW1 that he placed one blanket of the deceased to put out the fire appears to be false plea. Even if for the sake of argument it is believed that the wife of the accused was taking her bath in the bathroom as stated by DW1, then the question arises in the mind of the court how the jerkin containing kerosene came to the said bathroom when DW1 stated that only soap, plastic bucket and plastic mug were only kept inside the bathroom, and the wife of the accused came to the said bathroom holding only one sari in her hand. Further, the above self-contradictory statement of witness DW1, it can be gathered that he is stating falsehood that the wife of the accused committed suicide in the bathroom attached to the room meant to use constituent people situated at the spot quarter. The above evidence of DW1 is of no assistance to depict a probable story to disbelieve the prosecution case so far. Now, here, the learned trial court completely disbelieved the evidence of DW1. Basically on 3 grounds. First, that because he stated that he was holding a sari and came inside the bathroom. Second, the IO did not seize the half-burn blanket, which the DW1 stated that he used the blanket to extinguish the fire. Thirdly, my lord, the learned trial court gathered inference saying that once the plastic mug and the bucket inside the bathroom was undisturbed, the probability is when a person is burning, she will try to either put water or try to run away from the spot. And my answer, humble submission before your lordship would be, the circumstances has to be seen. First, the door was locked inside. And the burn was 100%.
No, one more aspect is there. There was no bathroom attached to that room, according to spot.
According to the spot. But bathroom is in the fireplace where the constituent people use. There are
Yes.
bathroom is, there were two bathrooms. One bathroom is attached to the bedroom where the MLA used to use the same. One room was kept for the constituency people. There was no attached bathroom to it,
Yes.
but the bathroom was separate from the inside the premise, inside
people of constituency used to
used
come
to
and
it.
see.
So
they use it little away from the.
But it is within the premises. It cannot be said that it was outside the quarter. It may not be attached, but it was adjacent to the room with a separate opening to the bathroom. The learned trial court tried to made out a case of convicting me on basically on few grounds. The first ground was, my lord, that once BW1 says that he was just holding a sari and going inside, there was no carrying of kerosene inside the bathroom. But when the IO visited the spot and he found one jerkin kept inside the bathroom. Secondly, matchbox was found. Generally, if a person carries a sari or a fake dress, matchbox is such a small piece that it can be hidden under a sari or in the pant even. So, the learned trial court tried to make out a case that because this jerkin was not carried by the deceased, so question of her body inside does not arise. Secondly, the learned trial court also said that once there is a burning, the natural instinct of a person would be that he will try to pour water. The circumstances were such that the tap was not open.
There is no violence of any kind.
Any kind. Yes, my lord is absolutely correct. My lord, when a person is determined to kill himself, my lord, why should he try to save himself? Suppose I want to hang myself and I make a
hanging is different.
My lord,
there is no scope for the person to come out. Here is a person independent.
Let us, my lord, say that it's a case of it's a burning. Admittedly, it's a burning case.
No, not burning. Self-immolation.
Self-immolation. He will never try to save himself because he is determined in his mind to kill himself. My lord, if a person does not open the tap and does not pour water, is the prosecution gets a fortification that yes, the accused must have killed him? The prosecution did not make out a case that the pouring of kerosene or burning was outside the bathroom. But if it would have been outside, maybe the reasons provided by the learned trial court would have been probably there. It was done within four corners of the wall, which was bolted from inside.
So you mean to say that the deceased was so determined that when she went inside the bathroom, stealthily carrying the jerry can and the matchbox, went inside, bolted the room, and became so concentrated in her act that even she did not move around, because little bit of moving around in the bathroom would have disturbed any of these things, or there could have been some violence. So she was so determined that despite the immolation, the pouring of the kerosene by herself, nothing disturbed.
Nothing.
And she was only raised a scream. Marioli.
She raised that scream. And, my lord, merely because the IO did not seize the blanket, cannot be said that there was no attempt by the person to extinguish the fire. My lord, the broken ventilators itself goes to show that there was an attempt to pour water inside the bathroom to save her. And my lord, the prosecution has also not made out the story that suppose, my lord, I go another step. The bathroom ventilator is such that a person can enter into the premises, block the door from inside, light the fire and come back. That is also not the prosecution case. Rather, the ventilator's glasses were broken, which were found beneath the body of the deceased. Means she was bobbing, attempt was made to break the glass ventilator, the glasses fell, they tried to pour water and she fell down. The injury which they are saying, my lord, it can be resulted onto fall. Because if your lordship sees the evidence of the doctor, there is no mark of injury in the back. So
despite the effort being taken from the ventilator side to douse the fire, there was no disturbance on the mug or the balti also, bucket.
Yes.
But somebody has stated that bathroom door opened.
The scientific team.
Yes.
Bathroom door was opened.
Yes. That your lordship may kindly see how he is there. My lord, may kindly turn to page 39.
No, your witness.
Yes, my lord.
Please come to that page 117.
Yes, my lord.
Paragraph 3.
Yes, my lord.
Last 3 to 4 lines you just read. Or after some time.
Yes. My lord.
117.
117, yes.
DW1.
Yes. My lord, I am reading the entire thing.
No. Read the 5 lines from the bottom.
After some time,
just go slowly.
My lord. After some time, smoke was coming out of the bathroom, and I heard the halla of the wife of the accused.
Stop there.
Yes.
My
lord, the se jo marigala kahila, he had heard it because the prosecution case is that. Yes, sir, then I tried to open the door of the bathroom but failed. Then I ran towards the room of the accused and called the accused from his room. I and the accused pushed the door of the bathroom with force and managed to open the door of the bathroom.
Ventilator
ventilators, they found that the glasses of the ventilator was broken and lying beneath the body.
Still, if that is the version, जे ସେମାନେ से कबाटा को बाड़ी खोल देले वेंटिलेटर देकिन पानी पकेवार स्कोप कोठी आछी
सर वेंटिलेटर we have tried
no nobody has stated don't imagine thing it might have been a stage management after that that is the reason so fast you see
sir
if you are applying force on a door and opening it there must be some mark of violence भीतर से कड़ी फड़ी मोड़ी माड़ी हे जो से गुडा किछि notice हेलानी
सर ସେମାନେ मेकआउट करि नहंती से जो कड़ीटा it was admittedly wooden door there were seals छिटका नथिला सर छिटकन दी रकम I am trying to make out a case in this way सर छिटकनटा जदि हम बंद करके तळकु करिबु then सर फोर्स रे at least तार जो एटा जोटा बंद पे लागि थबो सेटा भुगबो माने छिटकनटा सर भुगि पारे सर एठी मे भी छिटकनटा सर पूरा तळकु हे नथबो खाली जस्ट लागि थबो
किछि तो थिबो ना जेतोळे गोटे
आगु से पूछ देई छंती से yes right
स्त्री लोकटा जेतोळे बाथरूम रे गाधौची तो कबाट बंद करिकि नि गाधैथिबो ना जनरल जिंसडा
आगे
तापरे आपनकर किछि तो बंद करि जदि गाधैथिबो आपण एठु फोर्स दउछन्ती से पार्टी होउची जोर रे फोर्स दउछन्ती एवं सेटा खोली जाउची तमाने एटा इट इज लाइक इट इज फोर्स इज अप्लाइड एंड ओपन
यस
तामाने आपनकर कोन किछि तो थिबा दरकार से जोटा फोर्सिबली बाहर ब्लॉक करिया पई जोटा थिबो जहा भितरे आपण एटा मने कर
सर जदि तळकु लागि थबो सर गोटे जिनस आपण देखन सर सर जदि सिटकनटा खाली एंता प्लेन लागिबो सर मे भी पूरा लागि पारे न लागिबो जस्ट टिके लागि थबो जदि हाले पुशे खोली जाय पारे डिस्टर्ब न होई पारे जदि सर सेटा तळकु लागि थबो
in that case we can't tell it as use of force the moment you touch it means it will open
not always
DW1 first attempted
yes
open
yes
did not open
word
that means that was not likely to be opened so easily
the manner you are saying
the manner in which you are telling
yes
so when the this MLA came or the accused came, then maybe that both of them applied force.
Yes.
And thereafter the bathroom
Yes.
could be opened. So that
Yes.
means sufficient force was used to open the door of the bathroom. And in that is, if that is the so, it is your version, it is your case.
Yes, ma'am.
Then there should have been some kind of violence on or something on that door ଇଏରେ ସେଟା ଟିକେ ଆଟଲିଷ୍ଟ ଢିଲା ହେଇଯାଇଥାନ୍ତା ବା ଭାଙ୍ଗି ଯାଇକି ବାହାରି ଯାଇଥାନ୍ତା ତା ଭିତରୁ ଯୋଉଟାକ ଦିଆ ହଉଛି ସେ ଉପରଟା ହୁଏତ ବାହାରି ଆସିଥାନ୍ତା ଖୋଲିବାକୁ ଯଦି
ନାଇଁ ସାର୍ ଯଦି
କହୁଛନ୍ତି ପ୍ରଥମେ ଆଗେ ସେପଟେ ଭାଙ୍ଗିକିନି ପାଣି ପକେଇବାକୁ ଚେଷ୍ଟା କଲେ ସେଇଟା କିଏ କହିଲା ଆପଣ ଇମାଜିନ କରୁଛନ୍ତି ଯେ ଖାଲି ଯୋଉ କାଚ ପଡିଲା ବୋଲି କହୁଛନ୍ତି ସେପଟେ ଭାଙ୍ଗି ପାଣି ପକେଇ ଯଦି ସାମ୍ନା ପଟଟା ଖୋଲିଗଲା ସେପଟ କାହିଁ ପାଣି ପକେଇବେ
ଯଦି ଗୋଟେ ଲୋକ ଭିତରେ ପଡୁଛି they will try all the possible.
Who else was there? That is not the
there were two other persons of the constituent who were with whom the MLA
ବାଥରୁମ ର ଡୋର ଖୋଲି ସାରିଲାଣି ପାଣି ଅଛି ସେଠୁ ତ ଢାଳିବେ ସେ ଯୋଉ ଇଏ ଦେଇକିନି କାହିଁ ସେଠୁ ପାଣି ପକେଇବେ ମୁଁ ଭାଙ୍ଗିକିନି ତାକୁ
ସାର୍ ସେ ବ୍ରୋକେନ୍ କେସରେ ବି ତ ସେମାନେ ମେକଆଉଟ୍ କରିନାହାନ୍ତି ଯେ ଏଟା ସାର୍ ଆଗରୁ ବ୍ରୋକେନ୍ ହେଇଥିଲା କି କଣ ସାର୍ ଦି ବ୍ରୋକେନ୍ ସାର୍ ଆଇ ଜଷ୍ଟ ପୁଟ୍ ଏକ୍ସାମ୍ପଲ ଟୁ ମାଇ ସେଲ୍ଫ ଯଦି ସାର୍ ସେ ଭିତରେ କାଚ ପଡିଥିଲା
କାଚ ପଡିଥିବା ଇଜ ଏ ଫ୍ୟାକ୍ଟ
yes
କାଚ ପଡିବାଟା can be explained in this way that it has been everything might have been tampered in that way ହେଲା କାଚ ଭାଙ୍ଗିକିନି ଦେଖିବାକୁ ପଡିବ ଯେ ଏମିତି ଏମିତି ହେଲା ଯେ ଆମେ ସେପଟେ ଚେଷ୍ଟା କଲୁ ହେଲାନି ତାପରେ ଇଏ କଲୁ and you are the best person you are there in that house
yes I was there in
you are there in the house was it necessary on your part to take that plea that ଆଜ୍ଞା ଆମେ ଏମିତି ସେ କାଚ ଭାଙ୍ଗିବାକୁ ଚେଷ୍ଟା କଲୁ ତାପରେ ଏପଟେ ପଶିଲୁ you have not taken that plea you see your accused statement
yes
ମୁଁ ଜାଣିନି ସବୁ ମୁଁ ଜାଣିନି
yes only denied it
ସ୍ତ୍ରୀ ଘର ପୋଡୁଛି ବାଥରୁମ ରେ ଯାଇଛି you are present in that house nobody else except this PW according to you DW1 was present another man was present
and two other persons were present which the DW said that
they have not been examined
they have not been
examined ସେମାନେ ଯଦି ପ୍ରେଜେଣ୍ଟ ଥିଲେ it is up to you
yes
ଆପଣଙ୍କ ସ୍ତ୍ରୀଟା ଧର ସୁଇସାଇଡ କଲେ ବି ସୁଇସାଇଡ ର ପାର୍ଟି ବନ୍ଦ କରିବ ଯଦି ଆପଣ କଥା ହଉଥିବ ପାର୍ଟି ତ ନିଶ୍ଚୟ କରିଥିବ ନା ବି ହଉଛି ମରିଗଲି ସାଉଣ୍ଡ ଯଦି ମରିଗଲି ସାଉଣ୍ଡ ଶୁଣିଲା ସ୍ତ୍ରୀ ବାଥରୁମ ଭିତରେ ଏଡେ ଜୋର ଚିତ୍କାର କଲା ତାହେଲେ ସ୍ୱାମୀ ହିସାବରେ ଯଦି ଆପଣ କହୁଛନ୍ତି ଆମେ ବଞ୍ଚେଇବାକୁ ଚେଷ୍ଟା କଲୁ ତ ଆମେ ଦେଖିବୁ ଯେ ବଞ୍ଚେଇବାକୁ ଚେଷ୍ଟା କଲୁ କୋଉ ପଟରେ ନା ଆମେ ଏଇ ପଟରେ ଖୋଲିଲୁ ବାଥରୁମ ଜଣେ ଚେଷ୍ଟା କଲା ସେ ଖୋଲିଲାନି ଦ୍ୱିତୀୟ ଥର ସଫିସିଏଣ୍ଟ ଫୋର୍ସ ଆପ୍ଲାଏ ହେଲା ବାଥରୁମ ଖୋଲିଲା ବାଥରୁମ ରେ କିଛି ସେମିତି ଫୋର୍ସ ଆପ୍ଲାଏ ହବାର କିଛି ସାଇଣ୍ଟିଫିକ ଅଫିସର ଦେଖିଲେ ନାହିଁ ଆଇଓ ବି ଦେଖିଲା ନାହିଁ ଆଇଓର ଏଭିଡେନ୍ସ ଆସିଲା ଆପଣ ମଧ୍ୟ କିଛି ଏକ୍ସପ୍ଲେନ କଲେ ନାହିଁ ଗୋଟେ କହୁଛନ୍ତି କଣ ନା ସେ ଯୋଉ କାଚ ଭାଙ୍ଗିକି ପଡିଥିଲା ତେଣୁ ସେପଟେ ଆମେ ପାଣି ପକେଇବାକୁ ଚେଷ୍ଟା କଲୁ ତାପରେ ଏପଟେ ସେଟା କାହା କେସ୍ କେହି ତ କହୁନାହାନ୍ତି ଆପଣ ୟୁ ଆର ଦି ପ୍ରେଜେଣ୍ଟ ୟୁ ଆର ଦି ପର୍ସନ ଆପଣ କହିପାରିଥାନ୍ତି ନାଇଁ ନାଇଁ ଆମେ ଇଆଡେ ପଶିଲା ବେଳକୁ କିଛି ଲୋକ ଭାଙ୍ଗିକି ତାକୁ ଚେଷ୍ଟା କଲେ ମାନେ ଇଏ କରିବା ପାଇଁ
that is not there
so many things but nothing came in your statement
but my lord my humble submission would be that the entire incident had occurred inside the room and the room was bolted from inside it is not possible for a person to bolt inside that and commit the offense he cannot be
ଆଇଓ ଯେତେବେଳେ ଆସିଲା ସେତେବେଳକୁ ରୁମ ଅଲରେଡି ଓପନ ହେଇଥିଲା
yes
ତେଣୁ ବୋଲ୍ଟ ହଉଛି କିଏ କହୁଛି ବୋଲ୍ଟ ଥିଲା ବୋଲି
it is entire
your witness was stated
yes but the entire prosecution witness also they did not say that it was not bolted
ହୋଷ୍ଟାଇଲ ହେଇଗଲେ ଆପଣଙ୍କ ୱିଟନେସ ଟା ହିଁ କହୁଛି ଯେ ଏଇଟା ରୁମ ଟା ବୋଲ୍ଟ ଥିଲା ହେଲା ଆଇଓ ଯେତେବେଳେ ଆସିଲା ସେତେବେଳେ ରୁମ ଖୋଲା ଥିଲା ବାଥରୁମ ଖୋଲା ଥିଲା ଡେଡ ବଡି ଭିତରେ ଥିଲା କାଚ ପଡିଛି ଆଉ ମାନେ ବାଲ୍ଟି ସେଇ ଜାଗାରେ ଥୁଆ ହେଇଛି ସବୁ ଠିକ ହେଇଛି ସଫିସିଏଣ୍ଟ ଟାଇମ ମିଳିଲାଣି ତା ଭିତରେ ଆପଣଙ୍କର ଇନସିଡେଣ୍ଟ ଟା କରିକିନି ଏସବୁ ବହୁତ ଜିନିଷ ଷ୍ଟେଜ ମ୍ୟାନେଜ କରିବାକୁ ପିଲା ପଳେଇଛି ମନ୍ଦିର ନା କୁଆଡେ ଯାଇଛି ସେଇ ଯୋଉ ପୁଅଟାକୁ ମନ୍ଦିର ସେ ଡାକିଲା ଆପଣ PW1 ଷ୍ଟେଟମେଣ୍ଟ ଦେଖନ୍ତୁ PW1 କଣ କହିଲା
PW1, my lord, has stated, your lordship may kindly see. Paragraph 2 at page 79. I went with the son of the accused to the temple and we returned.
I asked the accused to accompany me to visit the temple. Seta पढ़ो जो paragraph 1 रे.
Last one.
Last one.
I know the accused. The occurrence took place on August 95 in the morning. It was Ganesh Chaturthi festive day. Occurrence took place in the quarters of MLA. I do not remember the exact quarter number. It was 7:30 am. I was living in the outside of that quarter. My family had also come. Accused along with his family members were also living in another outhouse of the same quarters. I asked the accused to accompany me to visit temple, but he allowed his son to accompany me and he did not go.
Yes.
I went with the son of the accused to the temple and we returned at 11 am.
Police already has said that.
We saw police person and other person had gathered there in the quarters.
देखो सी 7:30 रे गला 11टा बेलकु से फेरिला तारी भितरे घटनाटा हे जाई ठीक तो
यस
तेनु एठी रहिले किए जो जेतबेले
BW1 was there, the accused, the present appellant was there, and two other person then who have not been examined.
Two other person
We are not in that.
We are not in that.
Only two.
These two persons were there. Let us hold for the moment, but these two persons were there, the appellant and BW1. But then instead, we learned that the wife of the accused has set herself ablaze in the bathroom. As such, committed suicide. We saw the burned body of the wife, and the accused was recovered from the outhouse of the outhouse by the police. Exuberant were there. I lordship my skip. Your lordship can. After returning from the temple in the cross-examination, I came to know that deceased had committed suicide by bolting the door from inside. He had heard, he had not seen. I further came to know that the local people broke open the door and came to know about the occurrence. There was a ventilator in the bathroom, and after breaking open the glass of the ventilator, people tried to enter the bathroom. When they failed to open the door.
Whereas PW2, who is said to have turned hostile,
yes,
in his evidence, he has categorically stated that it was Ganesh Chaturthi festive day.
I
was for some time with MLA.
I
and accused were in the quarters. We saw smoking coming out of the bathroom.
Then we
saw the deceased had set her fire.
Just before the occurrence, I had not seen any quarrel between the accused and his wife.
Yes.
He says that a breaking of
he was the person
who was present in the house.
Along with the accused,
yes,
absolutely. So it's not PW1.
No. He is PW2.
May I point out one thing, my lord? My lord, kindly come to page 96, PW8, my lord. One subpara 9. 96 9 96 pages of 0.9 touch. The color paint of the bathroom door outside was swollen and bulged, but inside part of the bathroom door was less effective to heat than the outside. Means the door ta the bond thanta tal bhitor side ta bond hitan bhitor side swollen ta bhitor side heat aitana. As because the door is open, for which the outside of the door hochi swollen hochi one bulge hochi my lord. So how can you say that it is totally locked? And if you, my lord, go to the another aspect, my lord, no mark of violence was detected on the door frame, door bolt, and door of the bathroom.
room ta घटना बेले माने जो कोजनी broke open evidence होची केवल DW1 out to some extent ये जो hostile जो ये टा है ना बाकी जोड़ा factual ये देखिया गले जहाँ का आईओ देखिला बा scientific team scientific team ସେମାନେ କିଛି ଦେଖୁନାହାନ୍ତି ମାନେ ଯୋଉଡାକ ordinarily mark of violence ଟା ସେମାନେ ଦେଖୁନାହାନ୍ତି
0.9 को ଯଦି ଆମେ ये दबा मारो 0.9 रे
The door was open. It was not closed inside.
My lord will also kindly see the cross-examination portion.
So that means suppose the murder was committed inside the bathroom. Okay. So everything was done. Thereafter, एटाकू रखी दिया गला बकेट फकेट ठीक से साइज कर दिया गला कबाट टाकू बंद कर दिया गला सेपटू भांग दिया गला से जो काच भांग दिया गला टू टेक द प्ली दैट किछि गोटा ये कर एगुडा को हबार पॉसिबिलिटी अछि कारण यू आर गेटिंग सफिशिएंट टाइम.
But your lordship may also see the cross-examination by the defense of that PW8. Your lordship may kindly see.
PW8.
Yes. My lord, paragraph 3. I have not mentioned the size of the bathroom in my report, so also the size of the door and the ventilator. I have also not mentioned as to whether the door was made of wood, fiber or metal. The witness volunteers that the door was made up of wood. I have not mentioned whether the door and the ventilator were old or new. I have not mentioned the shape and size of the inner bolt or outer bolt and whether those were new or old. I have not mentioned whether the bolts were made of iron, aluminum, plastic or any other metallic. But as I remember, the bolts were metallic. It is not a fact that the bolts were not metallic and the door was not made of wood. I have not mentioned the total number of screws used in this door, so also the size of the floor of the bathroom. I have also not noted the type of color paints applied and total number of coats. I have not collected any material from the bathroom for laboratory test. I have not tested any material from the bathroom scientifically on the spot, and my report is based on visual appreciation without any microscopic tests. I have not indicated the directions of the face of the bathroom and which room was placed adjacent to the bathroom. I have not mentioned about the electrical wiring and electrical installation. The source of the fire in the bathroom might be kerosene. Other persons were present on the spot before my arrival. Though some other persons were present, I do not remember their names. I have not asked the cause of fire to any outsider present near the spot. I have not mentioned the time of the alleged crime in my report. I have also not inquired the same from the IO. I have not given any suggestion to IO to seize any material from the bathroom. I have not mentioned in my letter number and date of the requisition, but that is not it. Here, my lord, he has.
What is your plea? Let us know.
My lord, my
plea is that your wife attempted to commit suicide.
Yes.
You tried to save her.
Yes.
And broke open the door.
Yes.
Have you taken such a plea?
My lord, the entire evidence.
Statement plea नेबेनी आपण गोटे डिफेन्स विटनेस आनी दे देबे लास्ट को काकू सजेशन नाही किछि नाही हठात गोटे आनी साक्षी दे देबे DW1 रो जोटा कंट्रारी करूची माने ये एविडेंस गुडा
scientific team
और ये
मतलब scientific your lordship has seen both sides of the prosecution this scientific report as well as the defense. My lord, if your lordship sees that these points which he has framed, that these are the points which shows that the door was, that the articles in the bathroom were found intact, undisturbed.
कोटी गोटे लाइन कहछन्ती आपन को 42 टा क्वेश्चन पचारछन गोटे कोटी लाइन देखेले कोटी कहछन्ती आज्ञा मु सेन जबरदस्ती कबाट भांगी किनी मु पहुंची किनी मो स्त्री को देखिली एमती बाथरूम रे सुसाइड कला एक एंटायर आंसर पढंतु 42 टा क्वेश्चन आपन पचराई जी विभिन्न साक्षी ऊपर
मतलब even if I let us say my lord, even if I don't answer that,
you are bound to answer because in view of 106 of the Evidence Act, the burden is on you because you are the only person, you are the present in that house. Your wife was there and it was happening in your house, inside your house, inside the bathroom. And you are there. So you have to say how your wife died. And if you say that ଜଣେ ଯେତେବେଳେ ତା ସ୍ତ୍ରୀ ଚିତ୍କାର କରୁଛି ଯଦି ଆପଣଙ୍କର କେସଟା ହଉଛି ସୁଇସାଇଡ ଚିତ୍କାର କରୁଛି ଇଏ ଜଣେ ଆଟେମ୍ପ କରୁଛି ଖୋଲିବାକୁ ଖୋଲିଲାନି ଦ୍ୱିତୀୟ ଜଣକ ଆସୁଛି ଫୋର୍ସ ଆପ୍ଲାଏ କରୁଛି ଆପଣ କଣ ଭାବୁଛନ୍ତି ସେଟା ହାଉଲି ହାଉଲି ତାକୁ ଦୁଆରକୁ ଆରେ ଖୋଲ ଖୋଲ ଏମିତି ହେଇଥିବ ତାକୁ ଜୋରରେ ମାରିଥିବେ ନା ଗୋଡ गोड़ गोईठा मारथिबे हाथ रे ठेलथिबे जोर रे हुए तो माने जोर रे मारथिले हुए तो से कबाट भी माने ये जाइथांदा बहुत जिनस देखे ना
डेड बॉडी ऊपर पड़िथांता कोन
नहीं
No, Malab,
mark of violence.
he doesn't say that what is the material used in that bolt. And the scientific witness does not say what is the material used in it. He just says that I remember it is made of metallic. When he was asked the question that I have not mentioned the shape and size of the inner bolt and outer bolt and whether those were new or old. I have not mentioned whether the bolts were made of iron, aluminum, plastic or any other metallic. But as I remember, the bolts were metallic. He also does not give a definite conclusion. Then how he says that manner everything was intact? He could not say that. He is the scientific expert and he has seen that.
You see, if your defense witness version would be accepted, then there was question of breaking of those ventilator glass. Can you explain any? जदि आपनकर सामना बाट कबाटा खोली गला आपण एक्सेस आसीगला बॉडी पाखु सेटा बाथरूम जदि आपण सेव करिया चाहिए कल खोलिकिन सेव करिए पानी पकेबे बाल्टी जदि पानी भर्ती हिथिबो बाल्टी पानी पड़े सेपटे काई से काच्य भांगिला shows that after all these things are over you have managed to do many things. You have broke open that, you have managed to see that this bucket remains in order. Just see.
Sir, question is,
you are getting sufficient time.
Sir, question is that those broken glass pieces of the ventilator was found beneath the body. Sir, it was found beneath the body. Sir, it was not scattered inside the bathroom. Yes. Sir, if let us, what your lordship is saying, that if I have stage managed the show and I have killed and put the body in this place in the bathroom.
You have not killed anywhere. You have killed the body inside.
Sir, let us. Sir, I have killed her in the bathroom.
Yes.
After I have killed her, and if I have managed to break open the ventilator to picturize a case that I am innocent, I have not killed, and there was an attempt through that.
Right.
Sir, the glasses which were broken from the ventilator would have been scattered everywhere. Inside the bathroom. It was just found.
That is what is said. In normal course, what should be the reasonable expectation?
It was done prior. After she fell down.
If someone will try to pour the water from the side of the ventilator, breaking the glass, because probably glass was there.
Yes.
You say that it is ventilators glasses. So obviously it will be scattered. It can't be pushed beneath the body.
आपण जोडा कहउते एटा आपण अगेंस्ट रे जाउते आज्ञा
It can't.
आपण जदि सेटा भांगी थांदा जणे ताले चारि आडे खेळा आइगिन पड़ी थांदा चारि आडे जेहेतु खेळाई पड़ीनी ता तळे गेंजी देले
सर सेटा आगे रे पड़ी की बॉडी ता काटे पेंसिल करे सर सेटा नहीं करे
एक बार we don't say no. Correct. Correct.
Then in a case of this nature, since there is no eyewitness to the occurrence, so it has circumstance ro importance बहुत बढ़ी जाउची.
Yes.
जोटा कि आपण मध्य it's a law is very clear that man may lie, circumstances do not. That is one aspect. But circumstances can be planted also.
Yes.
Yes, that also thing the court has to keep in mind.
Absolutely.
On माने तदंतकारी ऑफिसर को गुमराह करिया पाई बा अन्य मान को गोटे अन्य पिक्चर दबा पाई बहुत जिंस यदि सफिशिएंट टाइम पाती एक्यूज्ड यूजुअली टेंडेंसी करती ताको स्क्रीन कर दबा पाई बा ता गोटे अन्य रूप दबा पाई तेणु whether it is a case of that nature that where कारण आपनकर वर्सन टा भी यदि आमे एक्सेप्ट करजु दीटा एक पॉसिबल होनी ब्रेक ओपनिंग द डोर and after opening the door when you got the access there is no question of breaking that ventilator and all these things because you have got the access and you could have easily thrown water on your body of the deceased तेणु violence आसुनी कबाट रे कोनोसी चिन मार्क violence नाही कि सेडा से ये गुड़ा पूरा टैक्ट अछि इंटैक्ट अछि गुड़ा घोड़णी गुड़ा तेणु आपण केमिति कहउछंती जे से सुइसाइड अटेम्प्ट थिला एवं ताकू एई पट दे आमे गलु एवं देखिलु रादर it probabilizes that other things no.
Sir, my humble submission would be prosecution has not made the item case in that way. Prosecution has not planned.
Prosecution जे एई टाइप रो केस रे एते जिंस आनिबा दरकार नै prosecution आनिला जे आपनकर बाथरूम रे घटनाटी हेची prosecution आनिला बाथरूम रे डेड बॉडी टा मिलिची बाथरूम रे जो बकेट टा पडिची बाथरूम रे मैस्टिक पडिची एवं बाथरूम रो धुआ हेची कला रंग हेची सब हेची ता ग्लास बैंगल्स करिया भांगी किनी पडिची आउ कोठी सेमिति चिन्ह नाइ तेणु माने किरोसिन पड़िबा बा अन्य कोठी ड्रैगिंग मार्क आपण जा कहले सेउडा नाइ तेणु व्हाट एवर थिंग हैज डन बीन डन दैट इज confined to that bathroom itself हला
yes.
बाकी क्वेश्चन रहला से एतिकी एकला second our prosecution anla je your presence which has been admitted by you
yes presence is there
right presence admitted occurrence inside the bathroom and these are the features hela and death is on account of burn injury right so now the burden shifts to you आपण burden केमती discharge करिवे it is up to you 106 समझे आपण आनिकिनी निजे प्ली लेलेनी अन्य किछि नै हठात गोटे सफेई साखी को देले सफेई साखी जो वर्सन देला we let us say that if his version is acceptable it's all right but whether his version is acceptable in view of the scientific evidence scientific officers evidence whether his version is acceptable what is he has noted in this spot ordinary year जोगुड़ाक एई गुड़ाक आपण जदि एक्सप्लेन न करिवे अब आपण निजे जदि से पी नौनाती ताहले डेफिनेटली it would indicate accusing finger against you.
So these are all being posed to embolden ourselves to see what is the circumstance.
Yes,
as you are putting the examples to yourself, we are posing this.
Yes, sir, absolutely.
And one more important aspect is that she is the wife of MLA.
Yes.
And having a washroom inside the premises, which is being used by the inmates of the house, how is it that she'll be using a bathroom of a bathroom which is to be usually used by the constituent people, the people who used to visit the MLA's house? That is also surprising, that she'll be going which is outside the house, not attached to the room, and she will abandon the washroom, she will not go to her own washroom and she will be going that side.
Apart from that, she was 25 weeks pregnant.
She was also...
that is another picture.
Yes.
She has a, you see, she has a son.
Yes.
She herself is pregnant. So in such a state, why she would kill herself? माने छुआटा गोटे छोटो छुआ स्कूल गोइंग बॉयज आ गोटे पिला माने पिला पेटरे अछि तो एई सर्कमस्टेंसेस कोन पई निजे सुइसाइड करिवो व्हाट वुड बी द रीजन जो आपण घटना जोडा कहउचनी सकाळे हां कोन टिके वाद विवाद हला एंड एते वर्ष लाडी बाहागर दैट कैन नॉट बी ए ग्राउंड टू ऑर्डिनरली एक्सेप्ट दैट ही वुड कमिट सुइसाइड.
Let me get myself more prepared to answer your question.
Yes, things we are posing this question to you.
Apart from that, the carboxyhemoglobin was not found in the blood. That means she was, but the death occurred after the before the burning.
जदि
it has not penetrated.
Yes.
पहुंची था जने जदि से गुड़ाक जड़ू था से ताले निश्वास इनहेल करता इनहेल करथले कोन होता ना तकर एडा ट्रैक रास्ता कार्बन कार्बन रास्ता somebody if it is dead then obviously तार सुंगीवारा और इनहेल करिवारा पावर नाही तण से भितरु पसिबनी सेत पई से माने देखिले जे विंड ट्रैक रे ये कोनोसी कार्बन सूट पार्टिकल नाही जोटा कि जने बंची थिले हिता आपण जदी कहउछंती जने अटेम्प्ट करिवो सुइसाइड हला सुइसाइड को अटेम्प्ट करले कोन होबो ना सेडा को सी अल्टीमेटली सुंगीबो ना याने पोडू सेडा सुंगीबो से पसिबो से निश्वास रे सेडा पसिबो निश्वास रे पसिले विंड पाइप को चले आस विंड पाइप गले ट्रैक रे सब से कार्बन सूट सोडा को मिलिबो एठी सेडा किछि मिलुनी तेनु व्हाट ही इज टेलिंग दैट ई जो तार जो हेड रे जो इंजुरी टा है जी maybe at that point of time she had date तापर एगुड़ा को पोड़ा ହେଇଛି जोथिपाई ता भितरକୁ ପଶିଲାନି ଯେମିତି let us say ड्राउनिंग केस आउ जण को फोपाड़ी देबार नईरे केमती जानिबो ड्राउनिंग केस हेले पानी पी जाए बंचिथिबा अवस्था पानी पीयो आपण जदि का मारी किनी पानी रे फोपाड़ी देले ता भितरକୁ पानी पसिबो पसिबो कि केस पसिबो ना that is how this difference is there तेणु एठी जो जिनस गुड़ाक हूँ आपण ये देखुना पोस्टमार्टम रिपोर्ट दे डॉक्टर एविडेंस देखो दैट मिस्टर
Yes, my lord.
मतलब PW7
PW7. No. PW9.
No.
PW9 PM doctor.
Of course, he did not. He said that it was not accidental.
Yes.
किंतु conclusively कही पारलानी जे कोई होमिसाइडल की सुइसाइडल से कहनी तेणु से छाड़ी देला बहुत केस रे मते जणा पड़े बर्निंग केस गुडा को बहुत समय रे conclusive हुए from the spot visit itself by scientific officer ये ला पर जणा
Several report is there. Page 122.
page
122.
कौन आसिला
The blood sample does not contain carboxyhemoglobin as confined by the
कितने पेज
122.
Your Lordship may also see paragraph 15 of the learned trial court.
Carboxyhemoglobin is a stable complex of carboxy carbon monoxide that forms in red blood couples when the carbon monoxide is inhaled.
But Your Lordship may also
Just a minute. So and so should be measured if carbon monoxide so and so is suspected. So and so is useful in monitoring production.
That is there.
Again.
Concentration
in homicide and death. In homicide and death,
where victims
where the victims are born to hide a method of death. Accelerants cannot be detected in the blood. Soot cannot be found in the airway. Carboxyhemoglobin concentration are not higher than those swanches. When soot cannot be detected by the naked eye in the airways of the victim found in the swanches, when carboxyhemoglobin concentration in the blood is no swanches, एगुड़ा कौन तार इए helpful in causing the death and confirming whether swanches. नॉर्मल कथा आपनको जेतबेले गोटे निया लागि जाए से सब उड़ुथिबो ना से कार्बन गुडा ये करी आपण इनहेल करी दिबो ऑटोमेटिक इनहेल करे एई जगह सोडा डिपोजिट हेइतो जाय ट्रैक हियर से तनु सेटु जणा पडियो जे ब्लड टेस्ट कर दी दिबो आपनको जणा
But if your lordship may kindly see paragraph 15 of the trial court judgment, where he has dealt with it. That is page 37. It is noticed from the statement of PW9 that he received the Xerox copy of the CE report from the SFSL, while memo number such and such dated. On perusal of Exhibit 17, the FIR, it is noticed that the carboxyl hemoglobin could not be detected by the chemical examination conducted by the Sahoo from the sample blood of the deceased, which was collected by the MO during PM examination. It is noticed from the statement of PW9 that the MO that he collected, the blood sample was handed over to the escort party in a sealed condition along with the letter of examination at SFSL from CHHOB carbox hemoglobin test. The original CE report is not produced in court by the prosecution. The prosecution produced two attested copy of the CE report in the court, which was marked as Exhibit Z. This said document is not proved by calling the person who attested the copy of the CE report. So, in my opinion, contents of the CE report cannot be taken into consideration in this case.
Which paragraph you are reading?
Paragraph 15 at page 37 of the paper book.
No, a formal proof of the CE report may not be necessary, unlike your PM report. That can be marked on admission also. But there is no objection to that, despite that the court has said that it is not. This was brought by PW9 IO.
Yes. No. IO. No.
IO evidence to this?
PW9.
PW11.
PW11?
Yes.
Santos.
Objection करना भी
नहीं बड़ा objection भी नहीं
objection नहीं so you say as an appellate court even if a witness has been disbelieved by the trial court we can believe it.
Yes.
If a document has been disbelieved, if we think that no, in accordance with law it is acceptable, we can accept it. There is nothing like that. So we are independently we have to
Because PM report cannot be marked without formal proof, but C report can be marked under 293 CRPC.
My learned senior stated that. I just brought to your lordship's notice
That the court has not accepted.
Yes.
Correct.
That much I only wanted to bring to your lordship.
That son is 11 years. And presence of fetus Sochi is 14 to 16 week.
Substantial.
ତାପରେ ଆପଣଙ୍କୁ ଯେତେବେଳେ ପ୍ରଶ୍ନ ସେଇ ଝଗଡା ବିଷୟରେ ମଧ୍ୟ ପ୍ରଶ୍ନ ପଚରା ହେଇଛି ଯେ ଆପଣଙ୍କର ସ୍ତ୍ରୀଙ୍କର ମାନେ ସାଙ୍ଗରେ ଆପଣ ଝଗଡା ହେଇଥିଲା PW2 ର ଏଭିଡେନ୍ସ କନଫ୍ରଣ୍ଟ ହେଇଛି 5 ନମ୍ବର କ୍ୱେଶ୍ଚିନ୍ ଦେଖନ୍ତୁ ପେଜ 70
Yes, my lord, I have seen that.
ମୋ ସ୍ତ୍ରୀ ସହିତ ଝଗଡା ହୁଏନି ତାମାନେ ସେଦିନ ବି ଝଗଡା ହେଇନାହିଁ ପିଲାଟାରେ ସେ କାହିଁ
What is the compelling circumstance that paved the way for the wife to commit suicide, having found all the ways foreclosed to her?
11 ବର୍ଷର ପୁଅ 14 ରୁ 16 week ର ସେ is having
pregnancy.
And there was no quarrel. If it is your case, then why she would commit suicide?
I have seen that paragraph 5, my lord. Question number 5.
At some point, the body is also found to be charred, no? That means it has burned for quite some time. Charred. ये कौन गला को जळुतला से बॉडी टार ड्राई फ्लेम बाहरुतला जे यार सो पड़ीगला सामनाटा विटनेस रो
DW1 has stated.
तार सो पड़ीगला माने ये कौन जळुतला जे पड़ीगला
eyebrow टा पड़िछि
and hair from
ଆପଣଙ୍କର ଦି ଜଣ ଯାକ ଯଦି ଗଲେ ଆପଣ ପୁରା ସ୍ୱାମୀ ଆଗକୁ ଯିବା କଥା ଆପଣଙ୍କର କିଛି ତ ହେଲାନି ଅକ୍ଷତ ଅବସ୍ଥାରେ ରହିଯାଇଛନ୍ତି ଆପଣ କେମିତି ପଶିଲା ଆପଣ ସ୍ତ୍ରୀ ଯଦି ପୋଡି ଯାଉଥିଲା ଜଣେ DW1 ରେ ଏମିତି ଟିକେ ଇଞ୍ଜୁରି ହେଇଗଲା ତାର ପୋଡି ଯାଉଛି ଆପଣ ଯାଉଛନ୍ତି ସ୍ତ୍ରୀକୁ ରକ୍ଷା କରିବା ପାଇଁ କିଛି ତ ନାହିଁ ଆପଣଙ୍କର ଆଟେମ୍ପ୍ଟ ନା ଆପଣଙ୍କର ପୋଡା ଦାଗ ଅଛି ନା କିଛି ଅଛି ପୁରା ଏକଦମ ସୁସ୍ଥ ସବଳ ଠିକ ଅଛନ୍ତି ତାପରେ 2 ଘଣ୍ଟା ପରେ ଯାଇ ରିପୋର୍ଟଟା ଦଉଛନ୍ତି ଯେ ମୋ ସ୍ତ୍ରୀ ପୋଡିଗଲା
report, my lord. In fact, report was given very early. Not that I waited and
no. Report at the stationary entry ହେଲା ପରା
UD case register.
report basis ରେ UD case ର କେତେବେଳେ ଆପଣ ରିପୋର୍ଟ କରିଛନ୍ତି এই ଘଟଣାଟା ଯଦି ଆପଣଙ୍କର
I informed the police.
No, you informed and that on that basis UD case was also registered.
Yes, ma'am.
What he says that what is the timing of the registration of that UD case? Para 26. So for page kete?
Page
74. ନା 74 ଟା accused statement.
ମୁଁ ଜାଣିନି
ହଁ କଣ କୋଉ କ୍वेଶ୍ଚन ଟା
26
he transfers so on the AC map ଦେଇଦେନେ on your written report ଆଚ୍ଛା ମୁଁ ଜାଣିନି ସେଟା ମାନେ dangerous
টাইমিং টা পুরো 10:45
10:45
ରିଟିନ ରିପୋର୍ଟରେ ଲେଖା
ସେଇଥିପାଇଁ
10:45 ମାନେ 7:30 ରେ ପୁଅ ଗଲା ହେଲା ତାପରେ ଯୋଉ APW1 କହୁଛି ତାକୁ ଟିକେ ଡାକିଲା ଇଏ ତାକୁ ନେଲା 7:30 ରେ ପଳେଇଲା 7:30 ପରେ ଘଟଣା ହେଇଛି ତାପରେ ଆପଣ 10:45 ରେ ଆଣିକିନି ଏତଲା ଦଉଛନ୍ତି ସେ ଏତଲାରେ PW ଭର୍ସନ ହଉଛି କଣ ନା ମୋ ସ୍ତ୍ରୀ To transfer from the evidence of PW1 that so and so. Acha. You reported the death of your wife due to burn injury.
My lord, information given, FIR was registered at the station.
FIR Purburi UD case registered.
Yes, 10-10. And the occurrence is 9 am.
10:40. You please come to PW10.
My lord, kindly see page 63 for a moment. The time is given.
Timing pra ye kohuchi pra IO kohibo se is the best person to say. Je registered korichi se kohibo na au ki kohibo. 102 pale asundu. 102 page re PW10 evidence. I was working at the SI of Police Kharbarnagar Police Station. On that day at 10:45, Sri S.C. Mahapatra did an IAC of so and so, registered 10:45 re registered kale on the report of the accused. Hala?
But if your lordship sees the FIR,
death of his wife, so and so,
if your lordship sees the FIR is also there, my lord, at page 63. The timing is, my lord, 10:10 am station diary reference. Entry number 36.
10:10 p.m. Yeah.
Sorry, man. 10:10 p.m. And 9 am is the day time of occurrence.
এটা রাতি 10:30 ବେଳେ 10:10 ରେ ଏତଲା ହେଇଛି।
ରାତିରେ ଦିଆ
এটা ଦିନରେ ହଉଛି ୟୁଡି କେସ୍ ହେଇଛି।
ୟୁଡି କେସ୍ ହେଲା 10:45 am ରେ ସେଟା ଦିଆ
9 am is the occurrence, man.
9 am ଲେଖା ହେଇଛି ଆଜିରେ occurrence, but 10:45 ରେ ଆପଣ ଏତଲା ଦେଇଛନ୍ତି, ଏଇ ଯୋଉ ରିପୋର୍ଟଟା ଦେଇଛନ୍ତି, ଯାହା ବେସିସ୍ ରେ ୟୁଡି କେସ୍ ରେଜିଷ୍ଟର୍ଡ ହେଇଛି। ତାପରେ ସେଇଦିନ ରାତି 10:10 ରେ ହିଁ ଏତଲା ହେଇଛି on the information of that ASI or SI KC person.
ୟୁଡି ଗଲା।
Circumstantial evidence ର ଯେତେବେଳେ ଜଣେ ଟ୍ରାଏଲ କରିବ ସେ ଆଗେ ତାକୁ ଡିଭାଇଡ କରିଦବ। ମୋ ଫର ରେ ଏତିକି ଅଛି, ମୋ ଏଗେନଷ୍ଟ ରେ ଏତିକି ଅଛି। ମୋ ଏଗେନଷ୍ଟ ରେ ଯେତିକି ଅଛି ତାର ୱିଟନେସ କିଏ, ତାର ଡକୁମେଣ୍ଟସ କଣ, ମତେ ଏଇଗୁଡାକ ଚେକ୍ କରିବାର ଅଛି। ବାସ୍ ତାକୁ କେମିତି ଓଭର ରାଇଟ୍ କରିବି, ମତେ କଣ ଆଣିଲେ ଏଇ ଜିନିଷ ସବୁ ଓଭର ରାଇଟ୍ ହବ, ହେଲା? ପ୍ରିପାରେସନ ଦରକାର, ତାକୁ 1 2 3 4 କରିବି। ସେମିତି ନ କଲେ ଫସିଯିବ।
I have seen my lord when my lord was this side doing trial.
Different color. That is the procedure.
Yes, ma'am. Absolutely.
Procedural 11 ର evidence ରେ during the investigation, my lord, I noticed that there are some marks of injuries on the dorsal of the right middle and ring finger of the right hand. On being asked, the accused informed me that the above injuries were caused due to scratching up by his own nail since he was suffering from eczema.
And that is not the ground.
That is not the report.
That is
not suffering from that.
ନର୍ମାଲଟା ଦେଖୁନାହାନ୍ତି, ଏଇ ଯୋଉ କାମଟା ଯିଏ କରିଥିବ, ଏଇ ଯୋଉ କାଚ ଭାଙ୍ଗିବାଟା ଯଦି ପ୍ରକୃତରେ ହେଇଥାନ୍ତା କଣ ହେଇଥାନ୍ତା? What my brother has rightly pointed out, ଯଦି ଭାଙ୍ଗିଥାନ୍ତା ପଡିଥାନ୍ତା ନା, ତାକୁ ତେଣୁ ମୁଣ୍ଡରେ ପଶିଥିବ ଯଦି ଯେ ନାଇଁ ଏମିତି ଗୋଟେ ଭାଙ୍ଗିଦେଲେ ଆମେ ସେଫ୍ଟିଟା ନବା ବୋଲି, ତାକୁ ଆଣି ଦିଟା ଭାଙ୍ଗିଗଲେ ତାକୁ ବହୁତ ଜିନିଷ ଟେମ୍ପରିଂ ହବାର ସବୁ ପସିବିଲିଟି ରହୁଛି। You have to explain many things that why it has not, ଆପଣ ଯେମିତି କହୁଛନ୍ତି ଯଦି ହେଇଥିଲେ ଏଇ ଟାଇପ ର ହେଇଥାନ୍ତା, ସେଠି ଯେହେତୁ ହେଇନାହିଁ, ତେଣୁ ଏଠି ଏ ଟାଇପ ର ହେଇଛି, ତାହେଲେ କଣ ଆପଣଙ୍କର ଏକ୍ସପ୍ଲାନେସନ କଣ? of course, if your explanation is acceptable, to give a plausible explanation, then of course it will definitely go in your favor. And जो circumstantial evidence of principle गुड़ाक पढ़िले, that each circumstances cannot be explained under any other hypothesis. It is not required that the accused should also explain. Yadi, if it can be explained at all,
yes,
accused may remain mum. Let us say accused किसी कहला चुपचाप रहला. Kintu whether it is acceptable that it can be अन्य circumstances रे explain हे. For example, आमे दोची जो धरो दी जनो लोक एठू कटक रु बाहरले गोटे डेड बॉडी 3 दिन पर मिलला पुरी रे हला ए प्रोसिक्यूशन ताको आनची लास्ट सीन आनियो अक्यूज किछि कहलानी चुपचाप रहि गला. So there is possibility that within these 3 days he might have come in contact with other persons. The possibility is there. So that can be explained. It is not that whether the accused has explained or not. इसी खाली कहबा आज्ञा मु धर नेइची मु आज्ञा चलली तापर आज्ञा मु ओले गली से एति होय त कहि पारे. କିନ୍ତୁ ତାକୁ ଆପଣ ଷ୍ଟ୍ରେସ୍ କରିକି ନବା ପର୍ଯ୍ୟନ୍ତ ମାନେ ପୁରୀ ପର୍ଯ୍ୟନ୍ତ ସେଠି ରହିବା ପର୍ଯ୍ୟନ୍ତ ଆପଣ କିଛି ଅଧିକା ଏଭିଡେନ୍ସ ଦରକାର. ତେଣୁ circumstances cannot be explained under any other hypothesis. ତେଣୁ ଆପଣଙ୍କର ଯଦି କାଚଟା ଭଙ୍ଗା ହେଲା ଆପଣ କହୁଛନ୍ତି ପାଣିଟା ପକେଇବାର ସେପଟେ ପସିବିଲିଟି ହେଇଥାନ୍ତା ସେତିବେଳେ ଯେତେବେଳେ ପ୍ରଥମ ଏପଟ କବାଟଟା ଖୋଲିବାର ସମ୍ଭାବନା ନଥାନ୍ତା ହେଲା. जो मोमेंट रे एपड़ कबाट खोलीगला सेपटे कहीं भांगिबो या पानी पकेउ चेष्टा करिवो एटा नॉर्मल जिंस. आपन केस ही होची आपन जेतेबेले आसीले अटेम्प्ट कले फास्ट से DW1 अटेम्प्ट कला से खोलनानी सेकंड टाइम फोर्स अप्लाई कले खोली गला डिसीज पाखु आपन एक्सेस आसी गला बाल्टी थुआइची कळ थुआइची स्प्रिंकलर अछि नै जणा नै गाधुआटा सेठी हां तनु आपण सेपटे आ जणे लोक काहे की पसिबो भांगिबो ताकू पानी पकेया पाई.
मतलब I'll try to inside bolt ता जदी ओपन थांता भांगिला माने से ओपन ही थांता बट इट वाज क्लोज भितर जदी बोल्ट दिया थांता तो बोल्ट बाहर की थांता
ताड़ी ही जीवन
ताड़ी गेले डोर
पूरा न भारली एंती
बंका एटा बाहर की थिबो
बंका ही बाहर जीवो एटा
बोल्ट बाहर की थिबो बट दैट इज क्लोज
वे तो पूरा से जो येटा न भारी पारे ता जो
साइटा बाहर एते टिके बाहर की रहियो
हां टिके
एंड दैट वाज क्लोज एंड आउट एज मींस से जो जेटा जळीची स्मोक ता दैट इज वेरी यूनिफॉर्म. जदि जणे जीवंत हिसाब जणे जदि जळुची different movement will be there, so this smoke will not be uniform. So when it is uniform means the dead after the death of the deceased it doesn't burn, so that the all the walls and everywhere the smoke is uniform. That is the also the scientific.
जणे जेतले पडियो माने से क्वाडे छाटिपिटी हो एठी बाडी हो सेठी बाडी हो इसु जिंस एवं सेठी कोन हो ना डिस्टर्ब पोजीशन
yes entire
and born even though someone is tried to burn himself herself or himself my lord, definitely at the time of the burning the pain and the that
no, that is how I put to Mr. Bose, and he said that no he will remain stand, he will not and then once a person who is he or she is determined, the bodily reaction is such that and it is an instinct. You can't stop. The body will not stop. There are certain things, no? The body has to do. It cannot. It has to react.
The pain and the automatic react.
It can't be. And see the time lag between the incident narrated by the witness. He's saying that the wife has gone inside and immediately thereafter he has heard. So the time lag is not very far. That the body will be entirely burnt and it is charred. And he's saying that still the body was burning. So which one is correct? It is only after a time lag that the body is allowed to burn and thereafter somebody is going.
आपण जो कहउछ ना बाथरूम रो बकेटटा आ येटा डिस्टर्ब हेनी थुआ हिची सेमती that is also another factor which goes against you. And जदि सुइसाइड जने करथांदा माने ठेला मेला ही करथांदा से ये रे हां ଏମିତି କେମିତି ପୁରା एकदम ସବୁ ଜିନିଷ ଅର୍ଗାନାଇଜଡ ହେଇକି ଥିବ କାଚ ଦିଟା ଭାଗିକି
Intact means I'm trying to intact means it was not burnt. It is the IO cannot say that it was intact in that place only. Intact means it was not burnt. Maybe.
No. Jerrycan was burnt.
Jerrycan was burnt.
When the jerrycan has burnt, and the pocket and
the scientific examination team did not say what is the distance, what is the entire bathroom, which is which size. The bucket and the mug may not be kept where she burnt herself. It may be little far towards other place.
The evidence of the IO, my lord, regarding this prohibition, the pattern of soot deposit of the bucket was found lying very close to the feet of the deceased.
Yeah, that was close to the feet.
ये जो स्पॉट मैप को आसुनांती आपण जो देखैछन्ती जोटा पेज होची 123
yes ma'am
तो सेठी पळे आसो तार घर को पळे आसो सीधा ଆପଣଙ୍କର ଗୋଟେ ଡେଡ୍ ବଡି ଚିହ୍ନ ଆगे ଏପଟକୁ ପଳେଇ ଆସନ୍ତୁ ଦେଖନ୍ତୁ ଲେଫ୍ଟ ସାଇଡ ନା ଏଟା ରାଇଟ ହ୍ୟାଣ୍ଡ ସାଇଡ ରେ ଦେଖୁଛି ଡେଡ୍ ବଡିର ଚିହ୍ନଟା ଗୋଟେ ଦେଖୁଛି ଦେଖିଲେ ଡେଡ୍ ବଡି ଟା ବର୍ତ୍ତମାନ କୋଉଠି ଅଛି ଦେଖନ୍ତୁ
ଇଣ୍ଡେକ୍ସ କରି ଲେଖା ହେଇଥିବ
ହଁ ଇଣ୍ଡେକ୍ସ ରେ ଡେଡ୍ ବଡିର ଚିହ୍ନଟା ଦେଇଛି ହେଲା ସେଇଟା ବର୍ତ୍ତମାନ ଏଇ ଯୋଉ ଭିତରେ ଆପଣ ଦେଖିଲେ you will get that
ସାଇଟ୍ ଗୋଟେ ବାଁ ପଟକୁ ବାହାର ଦେଖୁଛି ସେ ଚିହ୍ନଟା ଭଳିଆ ଯେ ଲେଫ୍ଟ ହ୍ୟାଣ୍ଡ ସାଇଡ୍ ଲାଟିନ୍ ସାଇଡ୍ ରେ ବାଁ ପଟେ
ଅରିଜିନାଲ ହଁ
ଲାଟିନ୍ ଯୋଉ ଅଛି ଦିଟା ବାଁ ପଟେ ତଳକୁ ସ୍କେଚ୍ ମ୍ୟାପ ଏଇ ଯୋଉ ସ୍ପଟ୍ ମ୍ୟାପ ର
ନା ମୁଁ ଏଇଟା ପୁରା ଅଧା କଟି ହେଇଯାଇଛି ସେ ଯୋଉ ଅରିଜିନାଲ ଟା ଏଇଟା ଦେବ ରେକର୍ଡ ଟା ଦିଅ ଅରିଜିନାଲ ରେକର୍ଡ ଏ ଯୋଉ ଡିସ୍ ଟା ଏଇଟା ଅଧା ତଳୁ କଟି ଯାଇଛି ଜେରକ୍ସ ଟା ପୁରା ଉଠିନି
ସାଇଜ୍ ଟା ଦେଖ ପଚରା ହେଇଛି ସାଇଜ୍ ଟା ଅଛି ପଚରା ହେଇଛି ଦେଖୁନ ମାଛ
ଏଇଠି ଅଛି ଲେଖା ହେଇଛି ଜର୍କିନ୍ ବି ସେ ଦେଖେଇଛି ଜର୍କିନ୍ ପଡିଛି ଇଏ ପଡିଛି ସେଗୁଡା ସବୁ ଅଛି କଣଟା ଦେଖୁଛ ହଁ ଦିଅ What visit here कैसे मार्क कीजिए
मतलब I'm saying
exhibit कैसे
injection मतलब spot map is
कितना कौन
15 man
15
exhibit 15
and the size of the bathroom is 7 feet 9 inch into 3 feet 10 inch. और left hand side रे देखुची dead bodies and that is out because you bathroom size टा होची मेरा 7 feet 9 inch रे 3 foot रे 10 inch रे माने very सरू माने evidence 10 feet 10
Oh, evidence. Man, I'm appreciate.
स्पॉट मैप रे हम रखिदो
spot में এটা lining ଦେଇଛି last ରେ double lining ଦେଇଛି କଟି ଯାଇଛି dead body
ହଁ ସେଟା ତ ନା
ସେ ଯୋଉ ଜାର୍କିନ ଫାର୍କିନ ବି ସେ ଦେଇଛି ଯୋଉ ତା ତଳେ ଲେଖି ସାଇଡ
ଏନଲାର୍ଜ ରେ ଅଛି ବୋଲି କହୁଛି କିନ୍ତୁ
ଆଜ୍ଞା
କିନ୍ତୁ ନାହିଁ
ଏଇଟା ତ ଗୋଡ ପାଖରେ ଯୋଉ ରାଖିନି ଏଟା ସାଇଜ ଛୋଟ ସ୍ମall ଦେଖୁଛି କଟି ଯାଇଛି
That is also admitted by the accused.
and the extreme southwest permanency of and then the flow of the
under the flag and various so see that from the line and facing of the assessment inside the line. Right? The body
Notes also, yeah. My personal notes, spot budget and income sheet for opinions. That is on the chairman. Order check, concept with created.
Questions are either ಎಲ್ಲ questions ಯಾವ್ದನ್ನು ಯಾಕಂದ್ರೆ ಇಚ್ಚಿರೋದಿಲ್ಲ ಪರ್ಸೆಂಟೇಜ್ ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಸೇರಿ and I'll work number here. And that way evidence it's a lot of las corridas populi se tanto rocketnato put nadi che carinato kan hanno volli corriere distance ଦେଇଥିବ ନା ଗୋଟେ ହେଲା ସ୍ମାର୍ଟ ଟେକ୍ନିକ ଦେଇଛୁ ଡ୍ରଇଂ ନେଇପାରିଲି
Yes.
Requires little more effort by my side. I'm lacking some effort to convince you that.
You have given you time to. We can take up tomorrow. There is no problem. But we want that it should be finished.
Well, can it be next Monday? If I can?
No, it should be finished within this week. Because after you will also hear the State Council. And you know what are against you now, you know.
Yes.
So you have to carefully again relook into the evidence, relook into the documents, and find out how those things which are available against you can be answered. Right? ଗୋଟେ ଗୋଟେ ନେଇଯିବେ ଆପଣ ମାନେ let us say scientific officer report ଅନୁଯାୟୀ ଆପଣଙ୍କୁ କୋଉଟା ଆପଣଙ୍କ against ରେ ଯାଉଛି. For example, you have taken a plea that sufficient force was given to the door to open, but the scientific officer found no mark of violence there. ଆଉ ସେ hinges ର କିଛି କୋଉଠି ହେଇନି. ତେଣୁ that is one circumstance. Second circumstance, ଆପଣଙ୍କୁ ଗୋଟେ plea ନଉଛନ୍ତି, ଆପଣ ତ ନେଇନାହାନ୍ତି କିଛି, ଯେ ଯୋଉ possibility ଅଛି ଯୋଉ ଭାଙ୍ଗି ଦବାର ଏଥିରେ scattered ହେଇକି ପଡିଥାନ୍ତା, କିନ୍ତୁ body ତଳେ ଖାଲି ଦେଖାଗଲା କିଛି ଗୁଡାକ ପଡିଛି, otherwise ସେମିତି କିଛି ନାହିଁ, ଚାରିପଟେ ଯେମିତି ପଡିବା କଥା ନାହିଁ ହେଲା. ନମ୍ବର 2, ବକେଟ ଆଉ ପୁରା ଏକଦମ ଯଦିଓ ପାଖରେ ଅଛି ସେ ବକେଟ ଡିଷ୍ଟର୍ବ ହେଇନି, ସେମିତି ପୁରା ରହିଛି. ଯଦିଓ ରିଆକ୍ସନ ହେଇକିନି ଆପଣଙ୍କର ଯଦି ଛାଟି ପିଟି ହେଇଥାନ୍ତା ତାହେଲେ ସେଗୁଡାକ ଡିଷ୍ଟର୍ବ କଣ୍ଡିସନରେ ପଡିଥାନ୍ତା ହେଲା. ତାପରେ ଆପଣଙ୍କର ଭିତରକୁ ଯାଇନି କୌଣସି ସୁଟିଏ ଯୋଉଠି କାର୍ବନ ମୋନୋକ୍ସାଇଡ ର ଆବସେନ୍ସ ଅଛି ବ୍ଲଡ, ଯୋଉଟା କି ଦେଖାଉଛି ଯେ ବୋଧେ ମାନେ ନିଆଁ ଜଳୁଥିଲା ବେଳେ ଇଏ ବଞ୍ଚି ନଥିଲା, ଅର୍ଥାତ୍ ଆର ଡେଥ୍ ହେଲା ପରେ ନିଆଁ ଲଗେଇଛି ହେଲା. Which was the kind, otherwise the soot particles would have entered inside, and in that event blood रे किसी carbon monoxide ଆସିଥାନ୍ତା, ଯୋଉଟା କି lacking କରୁଛି. ଇଏ ଗୋଟେ. ତାପରେ ଆପଣଙ୍କର plea ହିଁ ନାହିଁ total 42 questions ରେ, ଯେ ଆପଣ ଏମିତି ହେଲା, ମୁଁ ଗଲି ମୋ ସ୍ତ୍ରୀ ତା ଭିତରେ ଚିତ୍କାର କରୁଥିଲେ ଆଉ ମୁଁ ତାଙ୍କୁ ଏମିତି ଭାଙ୍ଗିକିନି ଗଲି ତାଙ୍କୁ ରେସ୍କ୍ୟୁ କରିବା ପାଇଁ, ତାପରେ ମୁଁ ଥାନାରେ ରିପୋର୍ଟ. ଏ ପ୍ଲି ହିଁ ଟୋଟାଲ ନାହିଁ. ଆପଣଙ୍କର ଫର ଦି ଫାର୍ଷ୍ଟ ଟାଇମ୍ ସେଟା ଗୋଟେ ପ୍ରେଜେଣ୍ଟ କରୁଛି ଥାର୍ଡ ପାର୍ଟି ଗୋଟେ DW1 ହିସାବରେ ପ୍ରେଜେଣ୍ଟ କରୁଛି. ଆପଣ ନା କୌଣସି ୱିଟନେସ୍ କୁ ସଜେସନ ଦେଇଛନ୍ତି, ନା ନିଜେ କିଛି ପ୍ଲି ନେଇଛନ୍ତି. ଫର ଦି ଫାର୍ଷ୍ଟ ଟାଇମ୍ DW1 ଆସିକିନି ସେ ଜିନିଷଟା କହୁଛି. ଏଇଟା ହଉଛି ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ. Then what Mr. Tripathi has pointed out, that you are having a 11-year-old son. You are yourself pregnant. That lady was pregnant for 16 to 18. And if you say that there was nothing, ମୋ ସାଙ୍ଗରେ କିଛି କଳି ଫଳି ନଥିଲା, then why that lady would commit suicide on that day? ଗଣେଶ ଚତୁର୍ଥୀ ଡେରେ ସେ କଣ ପାଇଁ ବିନା କାରଣରେ ସୁଇସାଇଡ କରିବ? So these are the things which are goes against you. You have to explain it.
Yes.
Think over it. We'll take up tomorrow. There is no
next Monday.
No.
Tomorrow, my lord.
Tomorrow, you see, next week is my Canadian year.
Hello, Monday I'll just take 15 to 20 minutes. I'll answer these 4 points raised by your lordship. Only 4 points I'll answer next week.
There is another death reference case. I think it has been Monday. That this bench will not be there. Maybe. Because ସେଟା ଗୋଟେ ରିପୋର୍ଟ ମଗାଇକି ଯୋଉଟା ଡେଥ୍ ରେଫରେନ୍ସ ମଗାବେ, ଆମେ ତ ମଗେଇକି ସେ ମାନେ ହିୟରିଂ ଅନ୍ ଦି ସେଣ୍ଟେନ୍ସ ରେ ରଖୁଛୁ, ସେଟା କ୍ଲୋଜ କରିବୁ ଜଜମେଣ୍ଟ ଦେଖିବା ପାଇଁ.
Can it be on Saturday? If Saturday is a working day for us. Saturday. 5th is a working day. Well, so that I get little time to
get people who see that. We take up, if you say we can take up on today is আজি के तारीख 30th. काली वाला 1-2 तारीख छुट्टी. We take up on 3rd. Oh, 3rd that. Third will get Kotak नहीं. No.
So 5th is the only day.
5th is the only day.
Fifth, if I may, don't put your lordships to inconvenience.
Inconvenience. It's a working day, issue.
Yes, my lord, we had availed that Nuakhai holiday on the 5th has been.
Working day, man. And today's list up to Fifth ballot. Today weekly list is up to fifth ballot.
Correct. Right counsel for the appellant has filed the written note of argument. Citation of statement. We should have taken on record hard in the part. Fifth of October 2020.
Yeah. 2 p.m. madam.
No, no, no. 10:30
ସେଟା 10ଟା ସେଟା ଆମର
ଶନିବାର 10:30
ଆଜ୍ଞା।
କେବଳ ସେଇ ଇଏ 7 ତାରିଖ ଦିନ ଗୋଟେ ଅନ୍ୟ ବେଞ୍ଚ ଅଛି ଆଉ ଏଇ ଯୋଉ କଟକ ବେଞ୍ଚ ଟା ଅଛି ଗୁରୁବାର ଦିନ
madam.
ଏନିବଡି ଇଜ ପ୍ରେଜେଣ୍ଟ ଏଇ ଯୋଉ ଅର୍ଡର୍ସ ମ୍ୟାଟର କିଏ ଅଛନ୍ତି ମାନେ
ଅଛନ୍ତି ତ
Item 2 admission. Item 2. batch cases ସାথେ ଗୋଟିଏ ଅଫିସ ରେ admit ହେଇନି। ହଁ ତାର ସବ ଆଇଟମ ରେ admit ହେଇକି LCR କଲ୍ ହେଇକି ଅଛି ସେଟା admit ହେଇକି ଖାଲି
କୋଉଟା admit
145 ଯୋଉଟା ଲାଷ୍ଟ ଆଇଟମ
ଅଛନ୍ତି।
ଗୋଟେ ଭୁଲରେ ଡିଲେ ପିଟିସନ ଫାଇଲ ହେଇଥିଲା that is no, there is no delay
145 of 18
ଆଜ୍ଞା
just a
there is no delay
just a minute
as pointed out by the
145 ରେ ଏଟା 2018 ମସିହା ରେପ୍ରେଜେଣ୍ଟ ଆଡମିଟ ହେଇନି
ନା
ସେଠି ଥିଲା defect was to remove
defect
shall be removed within a week leave this matter
8 ଦିନ ଡିଲେ ଥିଲା ଆପଣ ମନା କରୁଛନ୍ତି ଡିଲେ ତ ଅଛି 8 ଦିନ 3 ଦିନ ସରି 3 दिन ना 8 दिन कौन डिले 60 days नहीं 3 दिन डिले देखिए
सब आइटम रे
पर ऐसा नो डिले अच्छा जो ये ओ सॉलिड थिला पर फाइल ऑन चेक लॉन्च रेट ऑफ डिस्प्ले इटा लिखि जंतु ए देखि देले टिके एटा ऑर्डर शीट ता देखि देबे ओरिजिनल रिकॉर्ड ता देबे प्लीज गिव इट अस तो दिथर पुनी एडमिट
the only matter had come on 22/11 for admission
this case number 367 of 2018 is an application for condonation of delays. The stamp report has shown that there is no delay in filing the criminal appeal. Mr. Jafullah and counsel for the appellant petitioner does not want to place this application. Accordingly, this case is disposed of as not placed. Then it's a 302 appeal. Lifer. अच्छा hard admit for the trial court report. Trial court report from place it.
ଆଜ୍ଞା ଆଉ ଗୋଟେ ତଳେ ପେଜ
on the other place
76
It appears that the trial court record is available in both rates.
CRL 768 2019 sub item 3 sub
Not
item
received from the time.
trial court record receipt
TCR not received.
Not received.
ଆସିଲେ
हाँ सुनते हैं आपको पढ़ लो फॉल फॉर दी ट्रायल को अच्छा तापरटा एडमिट ही
ନା ତା ପରଟା ମୋର
सीआरएल 256 देखिन केते जण अप्लायड की माने अक्यूज्ड के जण
4 ଜଣକୁ ସଜା ହେଇଥିଲା 3 ଜଣ ଅପିଲ କରିଥିଲେ ଗୋଟେ
4 ଜଣକୁ कन्विक्शन ହେଇଛି
ଆଜ୍ଞା
let us see the operative portion of the judgment. Para 41. Therefore, on cumulative analysis of evidence and discussion made above, the court comes to the conclusion that the prosecution has failed to prove the charges under section so and so against so and so. But at the same time, the prosecution has successfully proved the charge under section so and so against Mokara Singh
against
alias Mokru Hemo alias Hemananda Singh, Butu alias Budhiram Singh, and Pokko alias Pakira. ଆପଣ ଯୋଉ ଫାଇଲ କରିଛନ୍ତି
ମୋର ଦୁଇ ଜଣଙ୍କର ଅଛି ଗୋଟେ ଫକର ଏଲିଆସ ଫକୀର ମୋହନ ବର୍ତ୍ତମାନ ଆଡମିଟ ହେଲା ଯୋଉଟା 145 ଟା ଆଉ ଆଗରୁ
ସେଟା ସିଙ୍ଗଲ ଆପ୍ଲାଣ୍ଟ ଥିଲା
ସିଙ୍ଗଲ ଆପ୍ଲାଣ୍ଟ
ଆଚ୍ଛା ଏଇଟା ତାହେଲେ এটা দুইটা ফাইল আছে বুদ্ধু সিঙ্গেল আপ্লান্ট
Budu alias Budhira.
এটা যে অ্যাডমিট এটা হলো ডিফেক্ট সিকুয়েন্ট তেত্রিশ দিন দিলে তারিখ হচ্ছে বড় বলেন 22/11/1999 defects will be removed. Drawing unit. Then measure around no fee or the तो आधर के आसुनाती आमे आमाई तो स्क्यूरी अपन को अपॉइंटमेंट कर दूचु ଆଉ ଆସୁନାହାନ୍ତି ଆଧର ଡିଲେ ଫାଇଲ ହେଇଛି ଡିଲେ କନଭର୍ସନ ଅଛି
ନା ଏଇଟା ବି ହେଇଯାଇଛି এটা কোথায় 1680 there is a delay of 604 days
সেকশন 256
তাহলে আর গোটে
এটা ଆଉ ତିନିଟା ଅଛି 146
768
ସବୁ ଆଉ ଗୋଟେ ମଝିରେ ଅଛି 256
আচ্ছা এইটা তাহলে হচ্ছে 768 ডিলে
76 ডিলে ଆଉ 256
768 defects was pointed out here.
Yeah, for sure. Yeah, good. Do you know this Janmejay Roy case? No. Janchandi? Janchandi of Roman National? Janmejay Roy, B. Saha, G.C. Rao, S.C. Manti, S.B. Bishwa. In this case number also, this is an application for condonation of delay. Since the stamp reporter has pointed out that there is delay of 33 days in filing this criminal appeal, since the appellant has been sentenced to life imprisonment, we are inclined to condone the delay. Accordingly, delay is condoned or admit. Call for the trial court report and further. That will be listed along with CRL number 145 of 2018 and CRL number 768 of 2019. है ना? CRL दिया 768 of 2019 में टेलीफोन में टेलीफोन में एडमिट किए এটা তো দরকার এটা কিছু লিখবে তো বলছে উপর দিকে দেখবে Bench admission. 3 নম্বরটা কোন এটা কি অপশন দি ফুল কেস
302 and 49 life engineering
ডিলে নাই
no
3 নম্বরটা অন করি হ্যাঁ ঠিক আছে Oh, please, no. So, hard admit कर देंगे item number 3 call for the trial court report. This case, review application for bail and stay realization of fine to be considered after the receipt of the trial court.
okay
Yes. କାଲି ନବା କେତେଟା ବେଲ ଅଛି
39.